We have a full house today. Good afternoon and welcome to the Appellate Division First Department. Please know that we have about 7 hours of requested argument time. I can tell you that the people at the end of this calendar don't want to be here that long. So please know that the court is fully familiar with your case, your briefs, the record, sometimes more than you wish we were. So please ask for only that time that you actually need, not the time that you want, understanding that while I will probably cut your time short, if your argument is such that my colleagues still have questions, I will permit the argument to continue. So don't get ruffled too badly by the cut of your time. All right. First case on the calendar, People versus Goran Logan. Okay. 5 and 2 and 5. Bryan versus New York City Board of Education. Okay. 5 and 1 and 5. M. Jelani is submitted. Max Gain LLC versus RAI. Okay.
Respondent 4.
5 and 1 and 4, and thank you. Herskowitz versus State of New York.
Appellate 5 and 2.
Okay.
And respondent request
5 and 2 and 5. People versus Conroy Hibbert.
Appellate request 4 and 2.
Okay. 4 and 2 and 4. River Park versus Harleysville Insurance. 4 and 2 and 5. Chapler versus Kachant. Okay. 4 and 2 and 4. Integrate New York City versus State of New York. Okay. All right, and welcome to the bar. I will say that New York City has over 100,000 attorneys, but we welcome you. And you would like?
City respondents 5 minutes, Your Honor.
Okay,
State respondents 5 minutes.
okay.
Intervenor respondents 5, and for VJ order, I also introduced my
Really?
2 out of 4 from out of state.
Okay. I'm not going to repeat my spiel. Welcome. The motion is granted. 5 and 2, 5, 5 and 5. Okay. People versus Arthur Strouder.
Appellate request 5 and 2, Your Honor.
Okay.
Respondent request 4, Your Honor.
4 and 1 and 4. See Children.
Appellate request 5 and 2, Your Honor.
Okay. All right. 4 and 1 and 4. Chan versus Havermeyer Holdings. Welcome. And the motion.
5 and 3 for appellate.
Okay, and
Respondent cross appellate 7 and 3 for the appellant cross appeal.
okay, 5 and 2 and 5 and 2, and the motion for Pro Hoc Vici is granted. Williams versus Plaxel Realty.
Appellant, request 5.
Okay. Do you have rebuttal time? All right, let's do 5 and 1 and 5. Perry versus Seda 3.
Appellant request 5 and 2, Your Honor.
Okay. 5 and 1 and 5. People versus Joshua Feliciano. Okay. 4 and 1 and 3. SHCMG-25 versus Archdiocese of New York.
Afternoon, Judge. Appellant request 5 and 3.
Okay.
Respondent request
5 and 3 and 5. Premier 1122 Madison versus Halston, New York.
5 for the appellant, 5 and 2, Your Honor.
Okay.
Good afternoon, Your Honor.
Good afternoon.
5
Okay, so let's do 5 and 1, 5 and 1. If we have extra questions, we'll keep going. BDO USA versus Stiles is submitted. First case on the calendar, People versus Goran Logan. You may proceed.
Good afternoon, Your Honor.
Good afternoon.
May it please the Court, Natalie Ray of the Legal Aid Society for Mr. Logan. The first question I would like to address is whether the 77-day DNA delay and the 106-day delay due to the witness's unavailability, both caused by the prosecutor's inaction, violated the speedy trial. And we believe the answer is yes.
With respect to the 106-day delay, were the people required to try to dissuade the witness from joining the IDF?
No, not at all, Your Honor. I think
Didn't
that,
they stay in contact with her and, understand when she was available?
So I think that, as to the due diligence, the requirement of due diligence of the people to stay both apprised of their witnesses' availability, the prosecutor we do not concede that they were in regular contact, but assuming they were, that they clearly didn't understand what the contact required for due diligence, because whatever their conversations were, it's obvious the witness left July 30th. On March of 2013, March 24 of 2014, the people announced ready, right? Had they been in contact and had they been having proper, meaningful conversations, they would have known that 6 weeks later, their witness was about to start basic training. At that point, I think that the cases require that there be some kind of a conversation about scheduling, and therefore ask her if maybe she could start basic training later. This was not somebody who was called, right? This was a volunteer. She volunteered in the Army. So at that point, she could have said, okay, can you start later? That kind of conversation. And she clearly didn't have that conversation because on the 24th, the people announced ready. Now, if they were ready, either they knew that the witness was here and could come, or they would have said, we have had a conversation, and she is about to start basic training, and we can't change that. Therefore, we cannot agree to the delay that was requested by the defense at this point. There's no evidence, these contacts that the people claim they've had.
Wasn't the defense request based on a trial they were on, that they were about to engage in?
Yes, but the DA didn't.
So that would not have mattered one way or the other, because if you are about to start trial as defense counsel, it's not like someone can just step in your
Well, there were more than one people in that trial, and that at that point, had defense known, maybe he could have said, let me ask for an adjournment in the other case, right? I mean, I think that to say, I have to be there, or maybe my colleague, the point is, the people didn't have to agree. At that point, they could say, we've contacted our witness, in 6 weeks, she's gone for the next 3 months.
Isn't the overriding issue is whether or not the person that is testifying is trying to delay the proceedings, and that's not what really happened, right?
No, and I don't think that that's what the Speedy Trial Statute is about. The Speedy Trial Statute is about preventing prosecutorial inaction. And in this case, both with the 77 days of DNA.
Oh, the 77th day, that's a good point. I'm glad you raised that, because at the hearing, there was a single hearing for both days, for
Yes.
both time periods. I didn't see, there were 2 hearings?
No. It
was
wasn't
one
for
hearing.
both time periods. It was for the entire motion.
It was for the entire motion.
Right. It wasn't. Right.
And it didn't break down the 77 days. No one talked about the 77 days.
Because the court focused on the 106 days.
Okay, so what does that do to the 77 days?
Because the court was right. If the court was going to deny the 106 days, it was dispositive.
Okay, so 77-day didn't matter.
If the court was going to decide that against us,
Okay.
there was
Got
nothing
it.
to say, right? So in both cases, both 77, both 106, it's about the people's inaction before they started. So they didn't ask for the DNA for 5 months. They didn't have the kind of meaningful discussions during the 9 months while the witness was absent. And we believe that both, that kind of inaction under Clark, et cetera.
My clock is not working, but you are out of time. So you'll have time on rebuttal.
What a surprise. I will address
Okay.
my sentencing.
No problem.
Thank you.
Good afternoon, Your Honors, and may it please.
Give me 1 second. Okay. The late arriving respondent on Perry versus Sater 3. Start time is 2 p.m. sharp, okay? And you have 3 minutes. You may proceed, counsel.
Good afternoon, Your Honors, and may it please the court. Julia Gorski for the people. With respect to the delay for DNA test results, defendant's claims are unpreserved. Defendant never argued below that the DNA evidence was immaterial. In fact, in their reply motion, they admitted that they were in fact challenging the people's due diligence in obtaining this, quote, key DNA evidence. Defendant also acquiesced in the hearing court's failure to address the DNA delay because he proceeded to trial.
That's bad. So essentially, you're arguing that the 77-day challenge is abandoned. They didn't go forward with it.
That's
And
correct, Your Honor.
there was no objection once the court made a ruling with respect to the 106th day or 102nd day, right?
That's correct, Your Honor.
So how do you respond to the argument that the people didn't do enough to try to, do due diligence?
Well,
Trying to ask her, can you postpone your volunteer, duty?
Okay. Yes, I'll turn to that. So here, it was very clear that when this trial commenced in May of 2013, up until the witness started basic training in April of 2014, the witness was ready, willing, and able to testify in this case. This was not an uncooperative witness. She was ready to return despite moving to Israel. As Your
There
Honors
was
have
no
pointed
indication
out,
in the record that that she joined to delay the proceedings.
that's correct. And as Your Honors have pointed out, the people had no requirement to persuade her or convince her to not join the military. The defense relies on People versus Friday and People versus Rickard in support of their argument that the prosecutor should have told the witness to hold off on enlisting in the military, but those cases are very distinguishable from the instant case. In Friday, there was a police witness that was unavailable because he was attending a training class that was also available at a later time. And in Rickard, that was a civilian witness who went on a vacation, and it was indicated that the witness was willing to reschedule that vacation for trial. Also, in both of those cases, a trial date was set. Here, May 6th was adjourned for status. It was not set as a trial date. So in those cases, asking the witnesses to adjust either their training class or going on vacation for a few days until the trial begins
It's very
that week.
different than enlisting in an army.
That's correct. It's very different than asking a witness to hold off life plans indefinitely. Again, we had no idea when this trial was going to start on May 6th. It was for status, and the adjournment was because defense counsel was starting another trial.
In fact, I think at the time she actually served, there was a conflict going on in that area, correct?
That's correct.
Which delayed even further her return to the States.
That's correct. So during basic training, it was made very clear by both her and her commander and the minister of the Israeli Defensive Forces that during basic training, you cannot leave. If you leave, you forfeit your service indefinitely. You cannot re-enlist. And then there was a conflict.
Not unlike our services.
And then there was a conflict between Israel and Hamas. Everyone, it was all hands on deck. No one could leave. That was also made very clear. And for those reasons, this case fell within the exceptional circumstances of the 30-30 clock, and defendant's right to a fair trial was not violated, to a speedy trial was not violated here. I will briefly address defendant's excessive sentence points. The sentence in this case was appropriate. Defendant is wrong to say that the kidnapping was his first known offense. Prior to the kidnapping, he had repeatedly assaulted the victim and unlawfully entered her parents' home, displaying a gun and a knife. The extremely disturbing kidnapping was the climax of a series of events that had occurred over the course of a year. You cannot separate it from the repeated instances of domestic violence and the burglary that immediately preceded it. Defendants claim that the court considered a sentencing range of 10 to 15 years appropriate on the second day of trial is not persuasive. That discussion with the court occurred on the second day of trial, halfway through Maya's testimony. The trial lasted nearly 2 weeks. At that point, the court had heard Maya testify to the instances of domestic violence, but it had not heard anything about what happened after she left the relationship, the burglary, or the kidnapping. The court also had not yet heard testimony from Maya's parents, the people they reached out to during the incident, their doorman, the domestic violence expert, or defendant's own testimony. Defendant argues that the court only sentenced him to a much higher term than was originally offered because he had annoyed it during trial, but it's clear that the court appropriately sentenced him to longer time only after hearing all of the evidence against him. Finally, these were not impulsive crimes of emotional despair. Defendant himself testified that he was happy in a new relationship, regularly going out with friends, and in a good place in his career at the time immediately preceding the kidnapping. Defendant admitted that he was telling Maya he wanted her back and was suicidal just to get her to respond. He also admitted that he had watched this family through their apartment window, lingered inside their apartment building on multiple occasions prior to the night of the incident. So clearly, these crimes were premeditated in an attempt to restore control over Maya. The domestic violence expert testified at trial that the most dangerous point in an abusive relationship is when the victim leaves, because the abuser's control is lost and the abuser is more likely to go to great lengths to restore it. That's exactly what happened here. And I did just want to note that the sentence was appropriate, that due to his complete lack of accountability, and the sentencing court understood that he posed a serious risk to this family. And based on the contents of his pro se submissions, which are submitted 10 years after his conviction, he continues to present a serious threat to that family as well as the Jewish community as a whole. There's no basis here to reduce his sentence in the interest of justice.
Thank you so much.
Thank you.
If I may, we're not saying that that this person shouldn't go join the army. Nobody ever said that. The question is the due diligence. What was the subject of their conversation? Did they try to ask her if it was possible for her to start later? And then I would like to address the sentencing also. 22 years in a case, first offense. It is a first offense. The fact that there are few misdemeanor level assaults, including in this indictment, we can describe the violence. These are misdemeanor level injuries. I don't want to belittle anything, but 22 years, first offense. I haven't found, and I haven't found a single case with a comparable sentence. I haven't found anything that's beyond 15 years, including with tremendous violence. In a case where the husband yanked his wife out of the bed where she was with her child. This is 22 years. He faced a possible minimum of 5 years. And
what are we to make, counsel, of the lack of remorse in his own papers, the pro se papers that he submitted?
Your Honor, I think that the lack of remorse at sentencing on appeal is a mitigating factor. Lack of remorse is not, because the case is still pending, and therefore he's allowed to argue what he wants at this point. The point is that it's a first offense.
What about the way
22 years, Your Honor.
The portions of the pro se brief that go after the judge for what seem to me pretty frivolous reasons?
Your Honor, there are a lot of unpalatable facts in this case. But the point is that this is a second-degree kidnapping with virtually no physical injury, and there are no comparable...
You don't have to get stabbed to be traumatized. He held this woman and her parents in their own home, hostage. I can't even imagine parents in a room next door hearing the craziness going on with their daughter and not being able to even get up out of their bed for fear that their daughter would be stabbed or shot. So I know you want to minimize all. Did we have to wait for one of them to be stabbed or shot to appreciate how incredibly dangerous your
Honor,
client's mindset is? And his statements in his pro se don't help him. So while you have articulated an incredibly thoughtful I've been in your shoes. An incredibly thoughtful argument. You recognize that this court has to balance the safety of the people that he continues to blame for his predicament.
Your Honor, as I said, there are some problematic facts in this case, but
That's to put it mildly. But I appreciate your advocacy more than I can say. I thank you.
thank you.
Okay? Ryan versus New York City Board of Education. You may proceed, sir.
Good afternoon, Your Honors. Jimmy Wagner for the appellant. I'm almost thinking I should come before you representing criminals instead of good, honest, Christian city workers.
That comment does not help you, and I would suggest that you give us your argument because you have articulated in the past wonderful arguments. So why don't we stay there?
No, and I apologize. I wasn't meant to be disrespectful. I was just trying to make some humor, bad attempt.
Okay.
I know recently, as of 12:30 this afternoon, my adversary uploaded additional decisions from this court in reference to Article 78 cases. I would easily be able to distinguish this case from Hogue because this case, in the brief, the appellants have to rely on the Hogue record 15 times. Not once, not twice. They actually reference Hogue's record 15 times in their brief because this record is absolutely sparse. The lower court in this decision recognized that the decision was sparse, and that's on page 818. The lower court said this record is absolutely sparse. There should be more factual findings. And this court in Reynolds versus New York City Fire Pension Fund in 2022 also said when you don't have a factual record, a court can't make a fair judicial determination what happened in the administrative decision. If we move forward and we take out the Hogue record references, what we have here is a record where page 69, this appellant's supervisor submitted a letter in support of her administrative request stating that under no circumstance was it required for this appellant to be vaccinated because this appellant, pre the Board of Health order, was already working in a special Department of Education remote program. So when we have the...
But was that a program? I understand it was a program for remote learning, right?
Correct.
And it was for children who were in high-risk medical categories and could not be in the school setting while the COVID pandemic was going on, right?
Correct. Those medically students, it was actually pre-COVID. They had issues that had nothing to do with COVID. A lot of them, whatever their medical reasoning was.
So the COVID was just extra?
Yes.
Got it,
So
okay.
she was a teacher in this special program where there was never any reason for her to be in a classroom. She taught remotely.
And she did get a medical exemption, Mr. Wagner, at some point.
And she did have, prior to making an application for a religious accommodation, this woman was granted a medical accommodation to COVID. The record is barren of why that medical accommodation was rescinded. I don't know why it was rescinded.
But you advanced a religious accommodation.
In addition to her medical accommodation, she advanced a religious
right?
accommodation.
And on this record below, before the panel evaluating the situation for her to get that exemption, doesn't it show that her own church allowed for the vaccination or encouraged the vaccination, and she wasn't relying on the values of her church or some protocol of her church, but was relying on her own holistic 11-point program? Isn't that what was before?
No, she was relying on her own relationship with her master, the Lord Jesus Christ, and the Holy Spirit. So this court in Williams versus Bright has clearly stated that American courts have no business endorsing or condemning religions. And Judge, what I I would say right now is it's not our position to endorse or condemn how this woman worships God. What she did say was she could get that accommodation. We're not supposed to.
But I don't think that any of the decisions condemned her religious beliefs. They just said that they weren't established to the required standard in order to support a religious accommodation.
So under New York City human rights law, first we need to look at the accommodation request. The accommodation request is to teach remotely. It was something she had already been given. If we look at the
But
whole
at the time that she made this request, was she currently in an assignment, a remote assignment?
She was.
Okay, so was there discussions that remote assignment, that the availability of those remote assignments was going to cease?
Absolutely not. And if we look at the record, again, it's record 66. Her supervisor supports the position that this woman could have continued her work without being vaccinated.
Okay, you'll have time on rebuttal.
Good afternoon, Your Honor. May it please the court, Rebecca Viscadas for the city respondent.
Are employees seeking accommodations for whatever reason limited to one reason? So she had a medical exemption already that had her working remotely. She then asks for a religious accommodation as well, right? Why remove the accommodation she already has?
So I believe the timeline here, to be clear, the medical accommodation that Brian had was not a medical accommodation from the vaccine. It was a medical accommodation from working in person during the COVID-19 pandemic, which many teachers had been granted in the prior school year when not all of the school population had returned in person yet. That accommodation was renewed throughout that school year up until some point in the summer, and then she was, before the vaccine requirement was announced, she was assigned to the home instruction program for fall 2021.
Meaning, so when you say that, meaning she would have to physically appear in school or was still on remote assignment?
She would have to physically appear in a DOE building. It was not a school building, but one of DOE's administrative offices where home instruction teachers were being stationed.
So again, it was a remote learning type situation. Why was that? Look, my point is, if she already had a medical accommodation, right? Unless what you're saying is that all of those medical accommodations were being terminated. Is that the case?
I cannot make that representation, and obviously the details of her medical accommodation are not in the record here.
So I am trying to understand why she went from an assignment that was in keeping with what she wanted. Why was that not at least maintained, even if the religious accommodation request could not be granted? She was covered.
So what I can say is that medical accommodation did not allow her an exemption from the vaccine mandate. It allowed her to teach remotely on a temporary basis.
This medical, I think I'm hearing you, the timeline is that these medical exemptions that were granted during the height of COVID, there was no vaccine readily. There was no vaccine, right? And so the change in policy came after the COVID vaccine became available. That okay, the medical exemption that we provided you, now we're going to want you to take the COVID vaccine, right?
Yes, that is my understanding.
Sounds like that's the timeline.
Yes, that is the essential timeline, and her.
Well, then I guess the question that my colleague's asking is, if she didn't take the COVID, why couldn't you extend the medical exemption for her? Or is that just wasn't available? That was just a position that DOE started taking. No, we're not doing that anymore.
Well, the medical exemption and whether she remained eligible for that is not at issue here.
not in the
Honestly,
record. It's not in the record.
It's not in the record whether she had applied to extend that medical accommodation.
Which goes to my colleague's point about how the only thing she applied for was the religious exemption, not the medical exemption, so that we don't know what would have happened had she applied for both.
Exactly. And of course, we acknowledge that the record here does not have evidence from DOE because of the procedural posture of this being denied pre-answer. So if this court does feel that these are questions that need to be addressed in determining whether the DOE and citywide panel determination had a rational basis, it of course can remand for DOE to answer and provide this information. We don't believe that's necessary based on this court's decisions, including the Lynch decision just this week, that DOE in general had a rational basis for determining that granting very similar requests for accommodations would pose an undue hardship because
Yes, but in those cases, the person wasn't already on an assignment that took them outside of the school, right? And so if she's not in the school, the need for the vaccination is not as great.
Absolutely, she was not physically present in the school at the time of her application. There's no indication that this was a permanent assignment or that DOE's needs for how many teachers they would need physically present in a school as opposed to in this home instruction program would remain constant even for that school year.
All right. Anything else? No. All right. Thank you. All right. You have 2 minutes.
Thank you, Judge. Justice
I want you to give me credit. I'm giving you an extra one.
I appreciate I do appreciate that, Judge.
All right. Good.
When we talk about the medical versus the religious, I would beg this court to apply the same standard. There should be no difference when granting accommodations, whether someone's requesting it for a medical reason or a religious reason.
Except that a medical reason, there's a way of documenting that. With the religious, it's more a subjective feeling, and there are other considerations. I think you can agree that we're not exactly talking the same kind of analysis, right?
Well, the analysis, I would argue, for religion is even stronger because religion is protected by the state constitution. In fact, the state constitution of New York states that no religion should be granted preferential treatment. And the city wants to rely on respondents'
But counsel, by that argument, every person that puts in for a religious exemption should be granted. There should be no questioning of the person's sincerity or genuineness in following that religion, because by your argument, it'll be very difficult to start. You can't just parcel people out, right? I mean, you're saying the religion is guaranteed, everyone has their right. So the minute I put in a religious exemption, there's no question, it's it.
No, so it's not, because this court had well-established rules that said, listen, if the request or the accommodation you're requesting interferes with your ability to do your job, then clearly you can't get it. The issue here is, for this appellant, we know it.
But that's not the only time when we have to say forget it, right? It's also if the request becomes so burdensome on the entity, and as we have discussed in prior cases, there were thousands. There was at least a good 1,000 people who put in for this religious exemption. And the Board of Ed said very clearly, we don't have 1,000 at-home positions that we can create to keep all those people working from home.
Right, but it wasn't, for teachers, it wasn't 1,000, and this record actually expresses that it was only 500. That's number one. But this teacher had been granted the accommodation, had previously had it. She had been working remotely, and different from this case, the Lynch case, Hogue, Lebowitz, there's no position statement. There's that affidavit by Eric Eichenholz isn't here, and counsel's wrong. This case was decided on the merits. They did bring a pre-answer motion. The court denied their pre-answer motion and went right to the merits. And in his decision in record page 818, he references the wrong standard again. He uses the de minimis standard when New York State, we use the significant hardship standard. I appreciate it, judges. I won't see you again until 2024. Happy Thanksgiving. Merry Christmas.
Same to you. Okay.
Don't speak so soon, you never know.
You're right. Thank you.
All right. Max Gain LLC versus Summit RAI. You may proceed.
Good afternoon, Your Honors. May it please the court. Jonas Weig for the appellants, the defense. Your Honors, we're looking at a very straightforward, classic scenario.
Your defense is that the text messages that went back and forth were sufficient to supersede the prior lease that was entered into by the parties, right?
The text messages jointly with the phone
Yeah,
conversation.
that's it.
Correct.
That's your argument. So how is it then, when I looked at the text messages, it seems to me they're missing a lot of material terms were missing. That's number one. And number two, the lease that was superseded has a provision in there that if you want to shorten or end or modify, it's got to be signed by both sides.
So, Your Honor, to answer those in turn.
I know it's a compound question, but. You know.
Not a problem. First, the text messages formed the basis of the contract in conjunction with the phone call that took place in the same window. The text message window where the four corners of the contract was created was from 10:54 to 11:31. The phone conversation was from 10:58 to 11:19. As per the affidavit of Mr. Rye, which under the standard of O'Brien and innumerable cases from the Court of Appeals and this court and others, all of the assertions of the defendant as the non-movement are accepted as fact, and pursuant to his affidavit, all of the essential terms were outlined between the parties during the phone call and in the text.
You're admitting that some of the you're admitting that some of the essential terms were oral, right?
Correct.
Yeah, but the lease requires a writing signed by both sides.
Your Honor, if I may return to that question in response to the second part of the prior question. Okay. All of the essential terms were covered between the parties. The parties mutually agreed on the entire amount would be an all-in $143,000 payment that would be due by January 31st, 2022, with unpaid balances thereafter to accrue at 8% interest per annum for 2 years until January 2024, at which point the entire balance would be due. All of these terms were outlined between the parties.
There's a but there.
Apologies?
There's a but there because doesn't the record show that your client in the phone conversation said, okay, let me put it together and I'll get back to you in a writing. And before he even got back to him in a writing, a principal for the landlord called and said, we don't agree that these are the terms that form a modification. Isn't that in the record?
Respectfully, I would dispute that characterization. The phone conversation happened within the window of the text messages. Following the phone conversation,
He says at the end of that conversation, I'll draft it up in the next couple of days. A week later, he still hasn't drafted it up because he gets a phone call from Lou saying that he would like to see everything is in good working order before I sign the deal with you. That became a contingency. That was a condition precedent to the contract. He had to go see the space and make sure that everything was okay.
Your Honor, our position is that that wouldn't be a condition precedent.
It sure is. He says, I won't sign until before I sign the deal with you, I have to see the space. That is a classic condition precedent.
That occurred after the text messages.
Yes, but you had no signed writing.
We don't need
And you were supposed to reduce the quote-unquote agreement into a writing as per the lease.
Your Honor, the text messages constitute that writing. Okay. As per
I got
so
it.
if we disagree with you, you're out. If we disagree with you that this was sufficient, that these texts did not have all of the material terms, that the statement, that your client's statement, I'll get it, reduce it to writing and get it to you in a couple of days, was not an indication that he understood that there had to be a writing, because to me, that's what that indicated. He understood. RAI understood there had to be a writing. Very good.
Your Honor,
I'll reduce it to writing and get it to you in a couple of days. And before he could get it to him, now you get a condition before I'm willing to sign. So you didn't have a deal.
Your Honor, we would, even if the court were to not accept the text messages themselves as a contract, which recent case law has established that messages, emails, etc.
Yes, I agree with you. I've been on those cases, but this ain't that one.
Even
This
if-
ain't that case.
Even if this court were to determine that the text messages may not have been a contract, at the very least, it would establish a tribal issue of fact.
Oh, I got a question for you then. Let's say I assume that I agree with you, that these text messages formed a binding agreement. How do you get around paragraph 28E, which says this lease or any provision hereof may not be modified, amended, extended, waived, or abrogated without the prior written consent of the condominium? So even if you got all that, you still need the condominium's consent before this can even fly. And I don't hear anything from you saying that the condominium would have said, okay, I would have signed off on it, I would have consented. I didn't see that in the papers.
Your Honor, the no oral modification provision shouldn't apply because there was a written communication. Additionally, there
No,
was...
but no, you didn't answer. The question was, would you have gotten the condos? Because it says right here, unless I'm reading it wrong, the condominium's got to consent too. So I don't have anything in the papers that would even indicate that the condominium association would have agreed to this written agreement that you're arguing exists.
Your Honor, respectfully, the condominium having signed off on the potential contract would not free the parties from their bound obligations under the terms of the contract.
So you're saying that provision in the contract was meaningless?
This contract
You
supersedes.
realize we cannot read any contract entered into in the state of New York and disavow a provision?
Correct.
Okay,
Yeah, I told you, she's right. We read everything.
okay.
There are no
You'll
further-
have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Magda Cruz for the respondent owner. Your Honors, I will be very brief. There was no agreement here, and it is absolutely clear, even from the text messages just that he is referring to, what he did in his brief.
But regardless, even if there were agreement, you still got to,
Yes,
unless I'm
yes,
reading wrong
as
this
well as
provision,
that.
you still need a consent from the condo. It doesn't matter what you
Absolutely.
guys agree to. You guys could agree to anything you want.
Right.
The condo says no, it's no.
Absolutely, Your Honors. And, you know, that certainly is in our brief where we discuss the lease provisions that require a writing signed by the person charged and also that the condominium has to provide its consent.
And this makes sense because the condo board is going to want to make sure whatever you guys agreed to is copacetic with them.
Absolutely, Your Honors. And the thing that is most pressing here, and I will be short, is the fact that the texts themselves indicate he was going to do a writing. He never did. And within the 2 minutes afterwards, my client's property manager is telling him, I have to look at the apartment in order to see if we can apply the security deposit, which was an essential element of the reduction in the rents.
Didn't shortly after that, the property manager, Mr. Liu, actually send a writing say, we just can't agree to it?
Yes, yes.
Period.
I am getting to that too. Yes, within a few hours after my client's property manager spoke with my client and said, no, we cannot make this deal. This guy has been promising to pay these rent arrears for a long time, and no, we're not going to cut 50% of the arrears, and we're not going to give him a 2-year period to pay. No deal. And it was returned in the same text chain. Your Honors, the lower court properly analyzed this case based on the clear facts. There was no agreement. If there is anything unequivocal in this record, is that there was no agreement, legally or factually, and no issue of fact at that as well. Thank you.
Thank you.
Your Honors, I'll be brief. All evidence past 1131, the final text messages, the ratification and the mutual assent of the contract should not be considered pursuant to the Court of Appeals. It's outside the four corners of the contract. Additionally, the parties ratified the contract by virtue of their course of conduct. $18,000 was maintained.
That would have happened anyway by operation of the lease terms. So that attempt at using the security deposit as some form of consideration when your client was in arrears on rent doesn't fly. Because by operation of law, they were entitled to seize on that $18,000. That's what security deposit is for.
Even with such an entitlement, they still would not be free from the obligations of General Obligations Law 7-108 to
No,
provide.
but you said that the use of the $18,000 security deposit somehow was a ratification of the oral agreement.
The $18,000 being maintained by the plaintiff respondent no longer was a security deposit, it was a payment, therefore their obligations under 7-108 were no longer in play. Additionally, the defendants did vacate the premises as pursuant to the terms 2 weeks later in February, thereby further ratifying the agreement. And if there are no further questions, we'll rest on the brief.
Thank you so much.
Thank you, Your Honors.
Herskowitz versus State of New York.
Good afternoon, Stephen Bergstein for the plaintiff appellant. We have two claims here. We have a disparate treatment claim, we have a retaliation claim. Let me start with disparate treatment. The plaintiff was fired after the defendant held him to a different standard under the sex harassment policy than a female coworker was held.
Were they peers?
Were they peers? Yeah. They were subject to the same policy, so they're similarly situated. A plaintiff was an attorney, the executive assistant was an executive assistant. It's not clear in the complaint if he was actually her supervisor, but the Supreme Court did say that since they were held to the same policy, they're similarly situated. And the plaintiff is held to a different standard because what he said to her—
Nobody made a complaint about the executive assistant.
Say it again?
Nobody made a complaint about the executive assistant.
The plaintiff did. He told the investigator when she was questioning him about comments he made—
He didn't make a formal complaint.
But under the—
Should we talk about retaliation?
Sure.
Is there something more than temporal proximity in the record of this case that shows that it was payback?
Yes, they waited until the report came out, which embarrassed the governor, and this is their opportunity to show solidarity with the Me Too movement, and, oh, we have a guy here that we can make an example of, let's get rid of him.
So it would have been too obvious if they'd gotten rid of him right after he gave his statement to the investigator.
Exactly. Exactly. Everybody knows you can't fire somebody for giving a sworn statement during an investigation. And take a look at what they charged him with based on the allegations in the complaint. Nothing he said or did to the executive assistant came close to violating any sex harassment policy that I'm aware of. And what she said to him certainly came closer. Hit it or quit it. That's a sexual comment. The complaint alleges that no one investigated her. She was never disciplined. And he was fired for telling her what? For asking for her phone number for work-related reasons. That's not sex harassment.
So that's one of the issues here, that the court really didn't take into consideration the entire context of all the conversations between him and EA to appreciate the innocuousness of his comments.
Correct. And this is sort of a perfect disparate treatment claim because you have two employees who were held to the same sex harassment policy, and their interactions with each other, you can compare them. And if anyone came close to violating the policy, it was the executive assistant, it wasn't the plaintiff. So that's,
Factually, I may agree with you. My concern is, how do we evaluate that when there was no complaint against her, right? So that they were not charged with investigating that. Now, that's not to say that I don't disagree with you that all of that interplay between him and the EA should have been explored and considered in the context of certainly of the retaliation claim.
Here's my answer. Under the policy, under reporting sexual harassment, you don't have to make a written complaint about somebody. A verbal complaint counts. During the investigation, he told the investigator what she said to him. That counts. Under the policy, any complaint, whether written or verbal, this is page 81, must be investigated by the governor's office.
So you're saying his response to the complaint against him, putting forward that, what are you talking about? I didn't sexually harass her. She was harassing me, should have automatically caused them to also turn an eye to her action.
Yes, any sex harassment investigator would say, wait a minute, tell me more. And we'll look into that too. That's your job as a sex harassment investigator. And the case law supports this. You can't ignore sex harassment once you become aware of it. There are regulations on this, and there are many sex harassment cases that say that. So
Now, how does the analysis get impacted by Mr. Herskowitz's statement that he wasn't offended by her comments? He thought it was just playful office banter.
I don't know.
How does that impact the scenario?
I don't know if he explicitly said, I'm not offended by it. He reported it. So the inference is that he was somewhat offended by it. Think about what she said about his date. Hit it or quit it. That's offensive. Drawing inferences favorable to him. He raised it during the investigation for a reason. He's like, look, you want to talk about...
But in the context, he's defending himself. So I don't blame him for now saying, are you kidding me? I get it. But he also said, well, I didn't complain about it because I wasn't bothered by it. Right?
But it would still implicate the policy. And, they should still look into it. You
Okay.
can't just ignore it. That's not something you say to somebody in the workplace, in the governor's office, I would think. And so somebody should have said, okay, give me more facts, write it down, let's look into it, and I'll follow up and I'll let you know what's going on. That didn't happen. So, on a motion to dismiss, we get into issues of motive and what people meant. You don't resolve issues of motive on a motion to dismiss.
Thank you.
Good afternoon, Your Honors. May it please the Court, Deanna Davidian of Arkansas Backen for defendant respondent, the State of New York. New York State has a policy that applies to all state employees and prohibits sexual harassment of any kind.
I have to agree with your adversary. The comments by EA were by far much worse than anything Mr. Herskowitz said.
I disagree, Your Honor. A couple things. The only comments that are attributed to EA is that she asked to see a picture of a person with whom plaintiff went on a date and said he should, quote, hit it or quit it. That's the only comment that's
Hit
attributed.
it or quit it. Let's not skip over that one.
Your Honor, the
Okay?
point...
Because hit it or quit it means have sex or don't, or leave that person alone.
Your Honor, in accordance with both the state's policy and the law, whether conduct amounts to sexual harassment is largely dependent on the recipient's pursuit of that comment. So, for example, whether
So what did she say hit it or quit it meant?
Your Honor, the complaint is clear, and plaintiff doubles down on this in his briefing, that he did not find her comments objectionable.
That wasn't my question. My question was, what do you say, what does the state say she meant by hit it or quit it? That has a sexual connotation to it.
Your Honor, the complaint is clear that the plaintiff concedes that her comments to him were
So you're just going to ignore what I'm saying?
Your Honor, the point is that here the plaintiff is trying to allege discrimination based on disparate treatment. He has the burden of alleging in his complaint facts showing that he and the comparator were similarly situated. And I think Justice Moulton hit it on the head when he recognized that there was never any complaint, whether oral, formal, written, informal.
But counsel,
there was no
but that,
complaint
I
against.
heard that argument, but your adversary made a very good point. When the plaintiff was being investigated, putting aside the thought that he thought it was, he didn't take offense to what EA, the executive assistant, said, but by the very nature of his response during the investigation that these comments were made by her, according to his argument, the policy is that the investigator should have taken that down and investigated further to see whether or not, they were accurate, whether or not they were credible, and whether or not it required any sort of disciplinary action. And that's where the disparate treatment comes in. They didn't do a full circle. They just did half a circle.
Your Honor, again, I would refer you back to the language of the policy as well as applicable law, which provides that sexual harassment depends on how it's perceived by the recipient. And plaintiff is clear that he was never offended by any comment.
So you're saying that if a coworker puts up a naked photograph in his office and nobody complains about it, the state can't do anything about that coworker's indecent exposure picture because that seems to be what you're saying. Unless somebody complains, you can engage in questionable conduct.
Your Honor, the policy provides that they do have a duty to investigate complaints.
Okay, good. I'm glad you said that. So now he says that she said to him, hit it or quit it. And the investigator doesn't think that that's something that should be looked into.
Your Honor, I don't believe that that one comment alone is sufficient.
But it wasn't just that one comment. That was like the icing on the cake comment.
That's the sole comment attributed to EA in the complaint, Your Honor. And I do not believe they were similarly situated.
Counsel, I'm sorry. I'm interested in the issue of retaliation here, retaliatory termination. You would agree that the protected activity was arguably in April when he testified, or when he gave testimony to the Attorney General's office investigating the governor, correct?
Correct.
And there is case law that, and then all this happened about 4.5 months later, his termination.
Correct.
And there is case law that has acknowledged that 4.5 months is not such a disconnect between the protected activity and the termination. You can agree with that?
Correct.
Okay, so in this context, you don't think it's a coincidence that suddenly they come down and terminate him after the report is issued on August 3rd, the very day that he's being accused of making the very statements that are an issue here? You don't think that's all unusual?
I don't think that's unusual, Your Honor. The report released by the AG's office is nothing new from the state's perspective, because the complaint's very clear that he participated in the investigation concerning former Governor Cuomo in April, that the state was aware of his statements during the investigation at the time that he made them in April. So when the report came out, by the way, the report doesn't mention plaintiffs specifically by name. It's clear that there's at least 10 women that the former governor is accused of sexually, or found to have sexually harassed, that they interviewed 179 people as part of this investigation. And in the complaint, it simply says that he corroborated some of the statements by one of the people. And again, the state had been aware of the content of that interview back in April. So again, there was, in fact, a 4.5-month time lapse, and that, as a matter of law, is not sufficient to show temporal proximity and causation. Thank you.
The cases in our brief show that 4.5 months is enough to draw a causal link from your protected activity to the termination, and the timeline is pretty tight. The report comes out, yeah, people knew there were allegations, but it was nothing like we learned from reading the report. The report was big news. 3 days later, he's questioned about these comments. The record does show what the plaintiff said to the AG's office when he was interviewed. He corroborated or substantiated somebody's claim against the governor. I'm not going to mention her name, but it's in the record at 289. There's some information about this. So that was an important allegation. And, you know, opportunity.
So the disparate treatment claim that you're arguing, right? I mean, there had to be allegations, and maybe I just overlooked them, that yet there were similar duties between the two, that they were sort of similarly positioned in terms of workplace hire. I mean, were those in the complaint, or are there somewhere else in the record that supplements the complaint that can show that?
Well, the complaint supports an inference they're similarly situated because they were both held to the same sex harassment policy, and they both worked in the same office. That's similarly situated. The Supreme Court said that. He did rule in our favor on that point. The 4.5 months, you know, there are cases. This is a problem with retaliation law. They're all over the place on how long and how short. You know, some cases go as long as 8 months. And when you have an opportunity to retaliate, when the opportunity strikes itself on a 3211, then you can accept 4.5 months because this was the time to do it. But even without the opportunity, there are cases in this court. Thomas versus Mintz, 2020, 6 months was enough of an inference. Thank you.
Thank you. People versus Conroy Hibbert.
Good afternoon, Your Honors, and may it please the Court. Jane Merrill for Appellant Conroy Hibbert. Lacking unquestionable documentary proof, the court below erred in determining Mr. Hibbert's motion to dismiss without a hearing. This case should therefore be remitted for such a hearing to determine whether the grand jurors who indicted Mr. Hibbert were exposed to impermissible and profoundly prejudicial.
We have an affidavit from the prosecutor who presented, who attested to the fact that the only portion of the OCME report that was put up on the Elmo for the grand jury to see was the very portion that the defense asked be put up. So now you want to use the very request defense made in the grand jury to try to throw out the indictment when there is an affidavit saying they didn't ask for it, we didn't show it. Had the grand jury asked for the document, we would have redacted it.
Your Honor,
What will a hearing show other than having a live witness testify to what the affidavit has already stated?
Your Honor, a couple of things. First, the affirmation is just not the sort of unquestionable documentary proof that the statute demands. Second, I would note that the defense request was entirely proper.
I'm not saying it wasn't, but it was at your request that that document was shown to the grand jury.
It was the defense request for an OCME criminalist to come and testify, not that the document be put into evidence. That was the prosecution's response to the request. But most importantly, I think what you're asking is, what's the point of a hearing given this affirmation? And I agree, a hearing would probably largely be duplicative of that affirmation, but it hasn't been subject to adversarial testing. And that's a problem in this particular context because the prosecutor is the only person available to testify who was a witness.
We should probably talk about the waiver issue too, counsel, because there are two waivers here, at least potentially. One was the appeal waiver, one was the plea of guilty. So how do you get around those?
Correct, Your Honor. As to the forfeiture by plea of guilty, that is simply not a problem here. A challenge to the integrity of a grand jury proceeding has been held to not be forfeited on appeal. So there is, I would direct
Is it
Your Honor.
really the integrity of the grand jury proceeding, or is something different that's being challenged here? It's what was put before the grand jury, whether or not there was hearsay evidence or the evidence that was hearsay nature put before the jury. It's not the proceeding itself, the integrity of the proceeding, right? I mean, there's a little bit of a distinction there.
There is some distinction, but this isn't just a hearsay issue, Your Honor. This is about Molyneux evidence, which does go to the very integrity of the proceeding because Molyneux is different.
You teed it up as a hearsay issue, though.
It is hearsay, it is also Molyneux, and that's, I think,
But
where
it's
the rub
only
is.
Molyneux if there's evidence that any of that hearsay was received by the grand jury, and there is none.
Well, there is some, because the grand jury transcript reflects that the entire exhibit was admitted into evidence, and I think Justice Neubauer below recognized that this was to some extent an open question because what the prosecution put in their affirmation, Justice Neubauer said on the record, was in some ways contradicted by what the prosecutor said in her instructions. And it's also clear that this wasn't unquestionable documentary proof.
Well, let me see. Under the rules of evidence, in order to read any portion of a document to a fact finder, that document has to be in evidence, right?
Correct.
You can't read from a document that's not in evidence. And so the prosecutor's affirmation said, yes, because the defense wanted the statement that there was no comparison possible with the DNA that was lifted, right? There was no profile that connected your client to the DNA profile from the gun, right?
Correct.
And the defense wanted that conclusion before the grand jury.
Correct.
Okay, now you wanted a live witness, they chose to do it by a report, understandable. OCME is quite busy, right?
Correct.
But there was no evidence that the factual recitation that was also contained inside that report, none of that was ever revealed, and there's certainly no testimony in the grand jury minutes that the court found was impermissible, because he reviewed the grand jury, she reviewed the grand jury minutes, correct?
Correct.
Please answer, go ahead.
Correct. Thank you, Your Honor. I would just note that the prosecution, or I'm sorry, what is noted in the grand jury minutes is actually unclear. What it says on page 15 of the grand jury minutes is the prosecutor says, I'm going to put a relevant part on the Elmo, and then reads the portion that Your Honor is mentioning about the DNA results, but that actually does not exclude the portion that is troublesome here, and I think
No, except that, counsel, if the prosecutor during that presentation had read anything else, the court reporter in that grand jury room was duty-bound
correct
to record it. So clearly, I don't think you're suggesting that it was said and not recorded.
Not at all, just that.
So just that they admitted the document into evidence, and what I'm saying to you is, by rules of the court, they would have had to mark it as a document in evidence in order to read from it, but the affirmation said they would have redacted had the grand jury asked to see it, and they didn't request it.
Correct. The entire document did not have to be admitted here,
Okay.
because there were many portions that I think everyone would agree are irrelevant.
hearsay.
There's police reports.
Right.
It's 50 pages. The contested portion is on page 2. It's not buried deep at all.
Right.
But what's not clear from the record, and what Justice Neubauer notes is contradicted by the prosecutor's instructions, which I don't have, are not in front of me, the defense counsel below did not have, is that there were later instructions, I believe, referencing the exhibit as a whole. And it's true, Your Honor, that the affirmation purports to lend some clarity to that. But that affirmation is needed in addition to what is in the record, which makes the record not unquestionable documentary proof, which is what is required by statute.
Thank you.
Thank you.
You may proceed.
Thank you, Your Honor. May it please the court, J.B. Masson for the people. Of the defendant's 2 claims, I'd like to just first quickly address his Bruin challenge. Following the clear precedent set forth by this court in People v. Adamus, at Artis, De La Rosa, and Swift, defendant's Bruin claim is similarly unpreserved, and there is no reason for this court to consider the defendant's unpreserved Second Amendment challenge here in the interest of justice. Even so, the defendant lacks standing, and his constitutional challenge is wholly without merit.
Because I think in Bruin Court and the U.S. Supreme Court in Kavanaugh's concurring opinion said, we don't mean to say that every felon can carry a gun. I think that was basically what he was saying.
Exactly,
Right?
that and
It's
for
an application process, the fall cause, right, issue that came up here.
yes, exactly for that and for
I
many
think
of
the issue that we were focused on during your adversaries is where you should focus, because that's the real issue of the day.
Sure, happy to, Your Honor. The claim that the defendant that this case should be remitted for a factual hearing should be denied for multiple reasons. The first is that this claim is waived by his valid waiver of appeal, or alternatively, his equally valid guilty plea. The denial of a factual hearing under CPL 21045 is simply not the type of jurisdictional defect or a claim of a constitutional dimension that would survive a waiver of appeal or guilty plea. And to Justice Moulton's question, the defendant simply cannot get around this. And this court only needs to look so far as People v. Hansen in order to see that. That was, of course, a seminal case that set forth that only rights of a constitutional dimension survive a valid guilty plea. And in that case, the question there was whether or not inadmissible hearsay presented during a grand jury presentation was a type of claim that survived a guilty plea, and the Court of Appeals said no. So for multiple reasons, there are significant bars for this defendant to even raise the claim that he was entitled to a hearing or that the court in any way erred by denying him the right to have a factual hearing. But even if this court were to set all of that aside and consider the merits, there was clearly no factual dispute in this case that would in any way warrant a hearing. Some of these points have been touched upon, but I just want to reiterate that we have a particularly unique record here in that the court could actually trace where grand jury exhibit 11 was throughout the entire proceeding. And this starts first with the unassailable grand jury record, in which the ADA was very careful to ensure that the record was very clear as to when she was holding grand jury exhibit 11, when she was reading from it, when she was admitting it into evidence, when she was displaying it on the document projector. And what is even more prescient here, salient here, is that she noted for the record when she removed grand jury exhibit 11 from the grand juror's view. She's saying, I'm taking this off the document projector. So she reinforced this through her multiple affirmations to the court. She reinforced those same facts, but she also added two important facts: that she had removed all exhibits from the chamber during the grand jury's deliberations, and that the grand jurors did not ask to see the exhibit. So from that, the court could easily infer that the ADA literally had possession of grand jury exhibit 11, and there was simply no way that the grand jurors ever saw any of the admittedly inadmissible portions of this particular exhibit. I think that alone, that record is enough. It's unassailable. It's clear that it was impossible that this grand jury presentation was imperiled by the inadmissible portions of grand jury exhibit 11, but the ADA went a step further. She, speaking as an officer of the court, she answered the court's questions and said that she remembers removing the exhibits from the grand jury chamber prior to deliberations because it is both her general practice and she had a specific memory in this case. So the defendant's fatal flaw here is that there is an uncontroverted set of facts that the grand jury proceedings had not been impaired by the inadmissible portions of grand jury exhibit 11. There was no factual dispute that would warrant a hearing in this case, and Justice Neubauer's decision not to grant a factual hearing should not be disturbed. Unless there are any further questions, I would ask you to deny the defendant's request to remit for a factual hearing and to affirm the judgment of conviction.
Thank you.
Thank you. I'd like to return briefly to the issues of forfeiture and waiver. As I mentioned before, this claim is not forfeited by a guilty plea, but it's not even waived by Mr. Hibbert's waiver of appeal. To the extent that this court finds that valid, and I'm not challenging that on this claim, but generally claims that involve a right of constitutional dimension fall outside the ambit of even a valid appeal waiver. That comes from People v. Lopez and People v. Shanks. And I think it's very clear that
How is this a constitutional dimension?
I think that's exactly the right question, and it's the right a right of a constitutional dimension because it is Molyneux evidence, and Molyneux evidence by its nature implicates rights of a constitutional dimension because it has the potential to implicate the right to be presumed innocent and the right to have a case proven beyond a reasonable doubt. So Molyneux.
So are you saying that your adversary cited Hansen?
I think Hansen is very different, Your Honor.
Why?
Hansen involved really a question of pure hearsay. That in that case, a newscast was possibly inadvertently played during the grand jury proceedings. There wasn't any allegation that involved allegations of a prior bad act. Prior bad acts are different. That's why at the start of trial, the prosecution has to make a specific application showing that the probative value outweighs the prejudice because it is so different. Hansen just didn't engage with that question because it wasn't at issue in that case. So I do
in this instance, the OCME report, the hearsay that was alluded to that you referred to as Molyneux evidence, involved the instant arrest, right?
It didn't, Your Honor.
No?
There was a somewhat unique set of circumstances here in that Mr. Hibbert was alleged to have committed the instant offense, and then a month later, he was alleged to have committed basically the exact same offense. And what was referred to in the hearsay that's at issue here is that second offense. And so it's not...
The second offense being the offense that got him arrested.
That got him arrested, but he was not indicted for, he was not I believe he was charged with it, but not indicted on that.
But wouldn't those facts, if I'm remembering my criminal law correctly, would have come in under res gestae anyway? I mean, at some point, the facts surrounding the circumstances of his arrest are likely to have come out anyway, in some form or another.
Probably not directly to the jury, although I agree that it's not impossible that this would have eventually come out, but it didn't, there was no need and no exception to Molyneux that it allows it to come out to the grand jurors, particularly in this situation.
Was this, I'm sorry, was this argument that you're making about Molyneux, was that teed up for Justice Newborough? Was that raised in front of her? You're making all these arguments about Molyneux and how, you know, it affects the Constitution.
It certainly was.
Was put in front of her?
It was in the defense's omnibus motion, and then the subsequent litigation, it's certainly there in the record. There were a lot of issues raised in that omnibus motion, but this was one of them.
That was one of them. All right, thank you so much.
Thank you.
River Park versus Harleysville Insurance. You can go right up. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the Court, my name is Lydia Deutsch, appearing on behalf of Appellant Defendant Harleysville Insurance Company in support of an appeal of the trial court's order granting respondent's motion on summary judgment for a duty to defend and indemnify. I'm here to discuss two issues. The first is that no work was being performed or was performed at all by the named insured on behalf of the non-contracting parties. And I look to the case cited by respondent Travelers, which confirms that the plain meaning of performing operations requires that the named insured actually be performing operations for the purported additional insured. Now, unlike the case in Travelers, unlike here, the named insured was aware that the ultimate beneficiaries of the work described in the purchase order were NBC Universal and Tishman, because the purchase order stated that NBC Universal's expectations did or could shape Atlas, the named insured in that case, says work. Here we have a very standard AIA contract. No such description like that exists. The contract here did not spell out that those non-contracting entities could have expectations that did or could shape the non-insured's work. Here, none of the work had any relation to any of the non-contracting parties other than the contracting party residences.
You're arguing that there need to be direct privity?
This actually isn't the direct privity argument, Your Honor. This is part of the clause that no work was performed by that had to be being performed on behalf of the additional insured. So this is the argument that's part of the Travelers decision. So putting the privity question aside and really focusing on what I think might be the heart of the matter before Your Honors is that here, there's nothing in the contract that says that there was any expectation that the non-contracting parties were the beneficiary. There's no indication to the named insured that the non-contracting parties, that they were doing work for the non-contracting parties. And in fact, the testimony in this case by the non-contracting, by respondent's representative, he said that the only entity for whom the named insured was doing work was the party to the contract, namely Residences, the owner. And he confirmed that he knew of, and he's the representative for the non-contracting parties. He said he didn't know that Renewal, the named insured, had done any work for any other party at all. I think that's pretty telling that this case is very distinguishable on the facts.
This is a construction case. So your client wants us to believe that they issued a commercial general liability insurance policy for a construction company and didn't know that meant that any of the subs who were part of the work would be part of the insurance. They didn't know that. That's like standard operating procedure in the industry.
I completely agree that the point here is that if the named insured could potentially be doing work on behalf of an additional insured. But here, that's just not the case. They weren't doing work on behalf of any of these non-contracting parties. It's in the contract to create coverage for that situation that you describe. It's just not here, the facts at issue here. And unlike travelers,
the named insured is renewal.
the named insured, that's correct. Your
Renewal. They were hired by River Park to be the construction manager.
Residence is the owner, the LP, and
There's just so many, let me tell you, there's so many tentacles here, just trying to figure out who's what and where. I mean, it's just amazing.
defer to-
So that's why I asked about whether or not the argument of privity of contract comes in, because a lot of it, if there is privity, all your arguments really go by the wayside, right? Because everybody's all connected and they have privity of contract. It doesn't matter if they were specifically named in the contract, insurance contract or not. They all have privity, so guess what? The additional insured, River Park, gets to bring in all the other guys because they're all in privity with each other.
All of their agents, employees, et cetera. That's the standard language. That is in this contract. So I really don't understand this argument.
Well, may I just address they're not arguing that this is, that they are in privity. They're arguing that privity is not necessary.
Right, because there's an absence of language in this contract that says, that language that's, and there's a federal district court case about this that involves Harleysville, right? And it says that the insured and the organization have agreed in writing to be additional insured. This contract doesn't say that. It doesn't have that requirement. It just says that, by the way, you got to get additional insurance. You have to have insurance coverage for the additional insureds.
If the claim is arising in a situation where there's work being performed by the nation on behalf, and I know
we heard you. I don't think that's your best argument, but we'll hear you on rebuttal.
Good afternoon, Your Honors. Christopher Wassliger for the respondents, plaintiffs. If I may please the court, I'll be brief. We do believe that Harleysville is in fact arguing that there needs to be privity of contract here.
Yeah, okay, I thought I was missing something because at the end, it just seems like it's just, they all have to be tied together. This insurance contract did not have that requirement of privity.
That's exactly right, Your Honor. The very broadly worded additional insured endorsement says that it confers coverage to any person or organization for whom the named insured is performing operations under a written contract that requires such person or organization be added as an additional insured on the named insured's policy. And here we have that construction contract. Counsel's correct that River Park Residences, the owner, was a signatory to the contract along with their named insured renewal. However, most importantly—
Counsel, could you respond to her argument about, it's not really quite the same as privity, but that rather that the contractor was not performing operations on behalf of some of the named defendants?
Yeah, absolutely.
Performing operations.
And to clarify, and hopefully we were clear in our brief, but the plaintiffs are the owners and operators of the premises, and Residences, for instance, is the beneficial and equitable owner, and then there's a managing, the rest are agents, or they're explicitly noted in this contract. And again, the broadly worded additional insured endorsement says for whom, not with whom, and the courts have explained that there's a difference, and for whom is broader, meaning that the entities seeking additional insured coverage don't have to actually be on the contract.
Right.
Rather,
That's the Travelers case, or the Travelers case so holds.
Yeah, and Vargas, which was decided by this honorable court, that was slightly different verbiage as required by written contract, but nevertheless, there are broader AI endorsements that and here in this specific instance, for whom, so long as what's dispositive again is that the named insured was obligated to procure coverage for these other entities. Here, the construction contract had required renewal to get additional insured coverage for owner and their—
even if the named insured somehow didn't, the insurance contract language bails them out because it's broad enough to cover everybody.
It's exactly right, Your Honor. It's right. It's incredibly broad, and so like that's the first question is, you know, whether all of these entities qualify as additional insureds on the Harleysville policy.
I think she was arguing, your adversary was arguing that, you know, the work wasn't done. It was not done on behalf of any of the not named insured or additional insured, so it doesn't, no coverage should even get triggered. How do you respond to that? I mean,
Yeah, I mean, so that's factually incorrect. They requested a deposition in this, and we produced a witness on behalf of all the plaintiffs. That individual is actually a principal of Reliant, the managing agent, not even Residence is the owner. And he testified that there's emails being exchanged during the course of this construction between Renewal and Reliant, one of these non-contracting parties. So they were fully aware that they were performing work for these entities, including Reliant. And with the broadly worded additional insured endorsement, all of these entities qualify as additional insureds. And then there's these allegations by WIMS that Renewal's negligent acts and omissions were a cause of the accident, and that's enough to trigger the broad duty to defend. And then just lastly,
Renewal was the GC.
Renewal was the GC.
And Reliant was the construction manager, right?
Renewal is the GC and construction manager, and Reliant and River Park Residences
Managing
and
the
apartments
premises.
We're the owners, the operators, the partners, the members. They're all the same entity, essentially. They're either designated in this construction contract explicitly on the signature pages, or we prove that they're the agents, and they were required. Renewal was required in the construction contract to get insurance for the owner and their agents, directors, and employees. So it's met. And, you know, just the last thing I'll say is the underlying decision with regard to indemnity, it's a conditional order. It's conditioned upon an underlying finding that Renewal is in any way liable for the accident, and that's going to trigger, you know, the indemnity cause in whole or in part. So, you know, it's our position that the underlying decision was perfect in all respects.
we're just in a defense posture right now.
I'm sorry?
We're just in the defense posture right now in terms of the cost of the.
Right, so the underlying case has not been, there's not been an adjudication of liability, but nevertheless, you know, based on this
It
endorsement.
never ceases to amaze me how many tentacles come out when it comes out to when you're doing subs, affiliates, whatever.
And just to clarify, we don't have any subs or anything like that. We're just the owners and operators, and there's the GC who's a construction.
Still count about 6 or 7 guys here.
Six in total, yes.
Oh, okay,
Yeah, it's
thanks.
a little.
More than one.
More than one, yeah.
Thank you.
Okay, thank you, Your Honors.
Thank you, Your Honor. Your Honors, I want to just raise my second point as I ran out of time. Liability of the owner cannot arise out of or be caused in whole or in part by the named insured's work because of New York law. So here, unlike all of the cases cited by respondent, which are labor law, the underlying situation is an employee who was injured on the job. This is a tenant who sued the landlord and other entities. We had not been in Building 40. This was a series of buildings. We'd not been in Building 40 or in this apartment for almost a year. And so the tenant, not an employee in the midst of a job site, so the liability that attaches here is different than the liability in other cases. And just looking at the complaint, it's record 35. It's all about the failure to maintain the duty of care. And those are responsibilities of the landlord. And then looking at the second complaint at 51, and throughout, it says that tenant alleges that the named insured entirely displaced the owner's duty to safely maintain the premises. But there's a limitation in this policy that says if there's no right to defense, if New York law says that you cannot be indemnified for this, and an owner's non-delegable duty is just that. It's not delegable, as opposed to labor law situations.
Except that the right to defend, the duty to defend is more broadly granted than the duty to indemnify.
I agree.
And typically you have to have the first before you get to the second.
I completely agree, Your Honor. And I would just direct attention to, at record 875, it states in the policy language states, this coverage does not apply for defense or indemnity of the additional insured if state or federal law does not permit indemnification of the additional insured by the named insured for the claim of the third party. And here, the claim against the owners is a non-delegable duty as owners. There's no possibility that they could be indemnified for that claim. Therefore, there's no duty to defend.
All right, thank you.
Thank you, Your Honor.
Chaplar versus Keechant Sewell. You may proceed.
Good afternoon, Your Honors. May it please the court. Chet Lukaszewski for petitioner appellant Chaplar. Your Honors, I know you've read the papers. Just if there's any question as to the visual, the one that really represents the scene, page 52 of the record. If you see this vessel and how small it is, even if you want to believe that my client, for no reason at all, decided to go out on the back deck on the high seas at night in the rain, in the snow, you would still have to crane your neck, get near the side of the boat, crane your neck to see the side wall, to see the platform. Imagine looking down a hallway and there's pictures, framed pictures. All you would see was the picture frame. You wouldn't see what was inside the picture frame from that vantage point. Also,
Yeah, but is that a risk that's associated with what he's doing on the boat, on
absolutely
that
not.
rescue boat?
That's like going out in a police car and having the brakes not work. This is a bolted-in piece of equipment. The analogy I gave in my brief is being guns drawn in a hallway, hearing the elevator come, stepping into the elevator shaft, and it's not there. 1,000 times out of 1,000, this is there. The one time it's not, that is not an expected risk. If you fall because of a wave, if you slip, if you're pulling even a body out and you get hurt, those are expected risks.
Explain to me, because he says that he attempts to drop down the other cover and he hears it. Why? What was it about what was happening on that evening, at that moment, that he could not discern that the grate was not there?
It's the weighting of the apparatus. And Your Honors, I don't want to be demonstrative, but if you look at the photo,
I know, I saw
you
the
can
photo.
see, so he can reach down. He's a foot or two from the water, and the dock is right there. You go over the side, you're getting crushed.
Right.
He knows in his peripheral, the release is there. The frame is steel. The grate that was missing is aluminum. The weight and the impact and the sound are nearly identical, especially with waves and wind and snow and the boat engine and his concentration being on not going over the side, not getting crushed, and doing something he's done 100 times before, me grabbing this pencil. If I grab a mousetrap, all I saw was the release handle. And they're expecting this. They're making the scenario seem mundane when it's life and death. And it's easy to go back and say you should have seen this. Even if you look
So how about this? What about this situation, a scenario where the metal grate's there, okay, the metal walkway grate's there, he releases it, the frame falls down in place, and the metal grate detaches, and he doesn't realize it detached, and he walks forward and he falls in. What happens in that scenario? Is that a risk that's that is normally related? I mean, that something malfunctioned?
Right, Your Honor. I think that would be like the case that Your Honors decided Gakel, where the scooter malfunctioned in a training exercise. There's certain things that if they are correct, and they happen 999 times out of 100, it's not an acceptable risk to say the one time it didn't. That's the out of the ordinary and the unexpected. To step onto that grate and have it detach for the first time in who knows how long, that would be the exact definition of an accident. This is just like that step in the third department case, Loia. They had put those ambulance stretchers in countless times. The time it's not there and the EMT gets hurt, that's the whole point of these coverages. When something that shouldn't happen, that they have no control over, that's not their negligence does happen, that's when the protections of the statute kick in. Here, there was no negligence on my client's part. To say that that grate was conspicuous based on the overall circumstances and the location is inaccurate.
Was he entitled to
Wasn't a
rely,
misstep.
counsel, on the inspection that was done by another officer? Because he was, in the normal course, supposed to inspect that night, correct?
Sure.
So he was entitled to rely on the previous inspection?
In the police department, it's a paramilitary organization. If they have one person doing a task, you're trusting in your brother, and not just here, your superior, to do that correctly. If he is saying the boat we're all about to go on is seaworthy, and you're a senior officer, he's not going to go redo the instruction. They're not going to wait for him to go do the checklist again. They had to get out on the security patrol. He had no choice but to rely on that, especially with the chain of command.
Thank you.
Thank you, Your Honors.
Your Honor, may it please the Your Honors, may it please the court. My name is Amanda, and I represent Abada, and I represent the city respondents. This court should affirm the lower court's decision because an accident, for the purposes of ADR benefits, is something that's sudden, it's unexpected, it's out of the ordinary, and it's an inherent risk of the work done by the officer. Here, despite all of the petitioner's protestation,
This is not something that normally happens. This is not something that should have happened. So by definition, sounds like a potential accident.
well, Your Honors, this court has held that where a defect is conspicuous and readily observable.
But it wasn't. And to pretend that it was is not fair to this officer.
Well,
you be on a boat at night in the snow under the conditions that this man was working under and tell me that he should have seen something in the dark of night in that condition. I think we're asking for him to be Superman.
Well, Your Honors, I would say this. I would say that, first of all, there was lighting emanating from the cabin house that's adjacent to the rescue well. That's one. And I would also draw this court's attention to the...
You would need a spotlight for that.
Well, there are two lights. So I would draw the court's attention to that. And further, the description that Chaplar has of how this all occurred, the fact that it was windy or it was inclement weather, it was dark at night, I would argue that that would be sufficient to maybe constitute an accident, but for the fact that he physically had to have looked at the platform cover in order to release it. I would draw this court's attention to the image on page 970 of the record, and if you look at that, you will see just how small this release is. So for him to be navigating his docking or to be doing the docking maneuvers and also be able to release this pretty small release pin in order to have that platform cover fall, he would have had to look at the platform cover, however briefly.
Counsel, also, the grate had a particular color too, did it not?
Yes, Your Honor, and...
It was yellow.
Yes, Your Honor, yes, and that it was on the dock. But the point is, Chaplar, first of all, also is an engineer, and admittedly, he was the one who was supposed to perform that inspection on the ship, and granted that he did not, but he had the capacity...
He would have known that there was a problem.
Well, he should have known anyway, because that grate was missing when he got on the ship. It was missing for the 6 hours.
But he didn't inspect it. So the only time that he had an opportunity to confront it when he had to close it.
Yes, Your Honor.
Right before docking.
Yes, Your Honor, but in order to close it, he had to essentially to look at it. And when he looked at it with his capacity as an engineer...
How many seconds do you think that would take?
Your Honor, I'm not...
You go like this and you flip the switch. I mean, it's not like he's... I mean, you know?
Well, I don't...
We have to employ some common sense into this scenario. And if you are on a boat in the snow, in the dark, and you are trying to tie the boat off and not get yourself killed in the process, there's a lot of variables you're paying attention to, right?
I would agree with that, Your Honor, but I also draw your attention to page 970, and with the release that you'd have to pull in order for that platform to fall and how small it is.
So, counsel, the way I hear your argument is that the missing metal walkway grate that's yellow is, part of the risk or inherent risk in the activity. So would you then say that if the metal grate were there and he walked across it and it collapsed, that would be an accident, right? That would be an accident. That would be sudden.
I wouldn't agree with that, Your Honor, because I would say...
You wouldn't agree that that's an accident either?
There are no accidents.
Oh, okay.
I would finish with this, Your Honors. I would say that working on a harbor boat and being an engineer on a ship, that falling on the ship, whether off the boat or in the boat, is a risk of the work that he's doing, especially since like there's evidence that Chapar presented that but for the launching and the docking, that rescue well remains uncovered.
Okay, thank you.
Thank you, Your Honors.
Your Honors, I appreciate you putting yourselves in his position and appreciating the reality of the circumstances.
Now, you realize, of course, that the case law is against us.
Not all of it. I don't think so. I think Loia is with us. I think Flannelly is with us. I think Vanazzo is with us. I think Pratt is with us. And I think if Your Honors will go back and read the excellent dissent in Pastelov,
Which, by the way, was I'm glad you mentioned that, because that one got appealed, and the city withdrew their appeal and gave that officer ADR after I wrote that dissent. So
I'm going to rest on that.
Nice.
Integrate New York City versus State of New York. Justice Oing is recused from this matter. If there is a tie, the court will vouch in another judge as per our court rules.
Good afternoon, Your Honor. Mark Rosenbaum on behalf of the appellants. The Court of Appeals and this court have repeatedly rejected arguments that civil rights anti-discrimination claims can be dismissed on the pleadings for lack of justiciability out of a concern for potential remedies if plaintiffs would prevail on those claims. Solely based on an incomplete and faulty accounting for potential remedies, the IAS court dismissed for lack of justiciability an entire complaint seeking to adjudicate violations, including by seeking declaratory relief of constitutional and statutory anti-discrimination rights. In its perfunctory order, the IAS court failed to reference, let alone analyze, any of plaintiffs' core allegations in this case, namely that defendants' policies and defendants' practices deny the students of New York City, particularly the most vulnerable of those students, a sound basic education and are racially discriminatory in violation of their constitutional rights. Adjudicating such questions is precisely the role of courts. Nobody disagrees with that. And so too is declaring, as plaintiffs have expressly requested in their complaint, so too is declaring that defendants' policies and practices, which have resulted in extreme and crippling segregation throughout the schools here. The outputs in this matter, Your Honor, are appalling, comparing what happens to those students who are in the unscreened schools versus the screened schools. Graduation, dropout, regents exams. As such, this case is squarely controlled by decisions of the Court of Appeals, including Klosterman and CFE1. And Klosterman, as I know you know, Justice Bandit, was specifically invoked in the Center for Independence of the Disabled case at pages 208 and 209, which held that the complaint there, an anti-discrimination complaint there, was justiciable on pleadings that are
Counsel, one part of justiciability is whether or not there are means of evaluation to courts about your grievances. Some of your grievances are very, seems to me, outside of the wheelhouse of courts. For example, the curriculum critique that you have. You know, your first footnote is to Isabel Wilkerson, who is an eminent author, but she's not a statute and she's not a precedent. And so a lot of what you seem to want, particularly with respect to the curriculum, is sociological stuff that we're not qualified to opine upon.
Your Honor, I take the court's point, but in this case, what the court did was to dismiss the entire complaint, including requesting declaratory relief on all sorts of matters. The guts of this complaint is twofold. One is that the children of New York, particularly Black and Latino children, are consigned to schools as part of a dual school system, a separate and unequal dual school system, where they receive an inferior education in schools that don't meet any of the standards of the CFE cases. Their facilities, their instrumentalities of learning, their access to teachers, none of that. That's one. The second part, and beyond the declaratory relief, it is on page 84 of our complaint, 95 and 96 of the record. It addresses the fact that in New York City, unlike any other city in the United States, in New York City there are tests, specialized tests, including the SHSAT, which were born in discrimination in 1971 to keep Black and Puerto Rican kids out of those schools.
No, you make that point very clearly in your complaint, that there's a pipeline that we're talking about. The SAT is actually at the end of that pipeline.
Exactly right. And this test which we allege, and the tests that were utilized before that process begins, as we allege, even with kids at age 4. There are tests in the 5th grade, specialized.
So why not focus on the complaint? I don't want to tell you how to do your job, but on the testing that starts the pipeline, beginning with G&T testing, and then the 4th grade testing, and then the screening for certain high schools, and the test for the 8 elite high schools. Why not just focus on that instead of telling us, that there need to be. We can't address the labor market, for example, to take another example, concerning the number of white administrators and white teachers, which is 52 and 55% or something along those lines, in a school system that's 85% children of color. So how do we address, that's a labor market question. How do we even get to addressing that?
And the strength of your point, Your Honor, is that the IAS court did not examine any of the core allegations, did not undertake the sort of analysis that you're taking about. We're prepared to go to court and argue about these matters, but in terms of the guts of the case itself, there are standards. Look, when I look at CFE 2, for example, what Chief Judge Kays said, 901, 905, 906, and throughout that opinion was, let's look at what it takes in order to determine whether kids can get a sound basic education. That meant talking to sociologists, talking to academics, talking to scholars to get those standards. And the court said, and this is reinforced in Klosterman, where the court said, look, there may well be policy matters that are touched upon. There may well be issues that are rife with discretion. But these are matters for which the court in CFE 1 and CFE 2 said standards can be set. And the crux of my argument this afternoon is that the court should follow the rulings of the Court of Appeals and the ruling in the Independence of Disability case, which controls this case, and put the caboose at the end and not at the beginning, and make a determination as to how those facts come in. Erb and Sutton Gate and Devine all say, let's see what the evidence is. If the evidence is that we have no case on curriculum, then that goes. If the evidence is that there's no case on a labor market, then that goes. But the sorts of facts that we have alleged and the failure of the IAS court to even look at those facts, to talk about those facts, to even address any of those allegations, and instead take an incomplete, faulty, completely mistaken analysis of the relief that we're seeking. We seek, it's Part B, we seek declaratory relief. That should be the end of this matter. Okay. And then we can fight out the questions of whether or not the sorts of claims, Justice Moulton, that you raise are appropriate, but surely the guts of them in one of the most segregated and unequal school systems in the United States, we should be permitted to go to court and to have an attempt to make our case. Thank you very much for your courtesy.
And tell me who you're arguing for.
Good afternoon, Your Honors. Philip Young on behalf of the city respondents.
Okay.
This court should affirm because Supreme Court properly dismissed these novel and unprecedented claims on justiciability grounds. That's because the wide-ranging harms that plaintiffs allege here, in order to remedy those, these are harms that stem from this complex web of interrelated policies.
But at bottom, counsel, the harm is one that we've been dealing with in schools for a long time, which is racial disparity in outcomes, racial disparity in resources. So that's not a unique, or not a novel claim.
What is novel, Your Honor, is the remedy that plaintiffs are seeking here. Page 95 of the complaint lays out a massive proposed remediation plan that would involve the
But don't we have to make the analysis one step at a time? And it seems to me if we're looking to the remedy, we're putting the cart before the horse. First, we have to decide whether, one, there is a justiciable issue. I believe there is, right? And then the question is, what, if anything, can the courts do about it? But are you arguing that the courts have no role on this issue?
No, Your Honor. I am not arguing that the courts have no role on this issue. What I'm arguing is that the justiciability doctrine is a broad policy prudential doctrine that allows this court, in its discretion, absolutely in its discretion, even where there's a cause of action stated, which again, we don't believe there is for reasons stated in our brief, even if there is subject matter jurisdiction, this court can exercise its prudential discretion and decide based not just on the cause of action, but also on the remedies and the way that this would involve the judiciary in the types of...
But haven't we, meaning the court, in cases such as this, previously said, there's a problem. Now you, state, you, legislature, fix it.
So I assume...
So why could this court not do that in this case?
I assume what Your Honor is referring to is the CFE cases. The first point on that is that the remedy there was quite narrow. It was focused narrowly on state funding.
Well, again, the remedy has to be decided later, but you want to throw out the baby with the bathwater.
I think if...
How about we look to see if the baby needs cleaning first, right? And it seems to me that based on the allegations in this complaint, we got a really dirty baby.
Your Honor, I think that there are many cases this court could look to, both the Court of Appeals and this court, where the court has focused on the remedy, not just on the cause of action, but also on the remedy, the extent to which it would require Supreme Court to engage in things that are far outside its wheelhouse. I just want to...
But how does this get, look, right? I read these briefs, these voluminous briefs, right? And again and again and again, I'm being told in these briefs that the court, this is not a justiciable issue. This is something that can only be remedied by the governor and the legislature. Then do it. So if what has to happen to get the legislature and the state to act is for the court to say, we declare there's something wrong. You are not fulfilling your constitutional duty under the educational article, fix it. We are certainly within our power to say exactly that. Now tell me why we shouldn't send it back and say exactly that.
Your Honor, I agree that generally this court has held that those types of claims are justiciable. Our point is that this is a unique case, and that the remedies plaintiffs seeking go far beyond anything that this court or the Court of Appeals have
So we
ever
create
said.
better remedies. Just because they ask for a particular remedy doesn't mean they're gonna get it, right? So that is what the process of litigation is for. They make one recommendation, you make another. That doesn't work for this reason or that, whatever it is. Because I agree that there are experts on the other side of this place that have a lot of information on how we should go about this. So I don't disagree with you that perhaps the appropriate remedy here is, as I suggest, that we seek a suggestion from the parties in interest on how to go about this.
Your Honor, I think just to sort of step back a second and think about from a practical perspective how a trial court judge in New York would deal with this, because the trial judge doesn't have this type of expertise in education policies, testing, all these sorts of things, they would presumably have to create a panel of experts or referees or something like that.
Well, if it got to the point of remedy, it may not get to the point of remedy, but at a trial, you would just be hearing from expert witnesses on both sides about whether the tests are discriminatory, about bread and butter type issues. You'd be hearing from experts, as we always are informed by experts in cases that are beyond our ken.
Absolutely, Your Honor.
And if we can understand experts in AI, trust me, this is not a problem. So.
Absolutely, Your Honor. I understand that point. I would just say that, even if that's true, that some of these things can be discussed and adjudicated in a trial, when the remedy sought here is so broad and capacious, like it is in this context, that would take the court far, far outside of its judicial.
But one of the remedies they sought was a declaration. That there is no problem in giving them a declaration if we find the facts as they lay them out are accurate. No problem whatsoever.
So I think just two very quick points on that, Your Honor. One, our view is that from a functional perspective, a declaration is essentially telling the city that there are certain specific policies and programs that they have to enact, which is ultimately...
No, it's saying review how you have implemented the law, because it's failing. Okay, we cannot just keep on saying, oh no, this problem is too big, there's nothing we can do about it. Meanwhile, thousands and thousands and thousands of children keep on being graduated from a system that's not teaching them. But such as it is, our time is up.
Thank you, Your Honor.
You may proceed.
May it please the court, Mark Rube for the state respondents. I'd first like to direct the court to the Painter v. State decision, which said that on a motion to dismiss, the court can look at whether the plaintiff has suggested any possible remedies that match their theory of the case or their request for relief. So it's appropriate at the motion to dismiss stage to look at whether there are any credible remedies. Of course, they're not limited to what they've said in their prayer for relief, but they haven't suggested any narrower remedy that a court could manage that would not involve entangling the judiciary with the day-to-day operations of city schools. And so for that reason, the Supreme Court correctly held that the dispute was
So we do nothing?
Well,
I mean, because that's it. Look,
that's
in essence what you're saying. We have standards that local districts can use or not use. They can implement them or not implement them. So they're saying we should have one of their suggestions is we should have a monitoring mechanism to make sure that the standards that the state is so very proud that they created are actually implemented. What is the sake of having a policy on paper that nobody has to follow and that there are no consequences for not following?
Well, I have a couple responses to that. First of all, with the separation of powers doctrine, it's the people and their power to elect their representatives that address the problems through the elected branches. But also turning to your
what if there's counsel? Don't leave that topic. I mean, there's sometimes a failure in the electoral process, and it doesn't work.
And I also do want
this has been an intractable problem for some time. And I actually was saying this is almost too big. It encompasses too much. Let's just talk about, for example, the SAT. That's been debated since the 1970s. It's not, and it hasn't been fixed. I'm not saying the test is necessarily unconstitutional. I'm not making any statement about liability, but it's certainly been a problem that's existed for some time. And same thing with criticisms of the G&T testing that goes on. Those are things that can be addressed, I think.
Well, as to those are issues that the city controls. And
has
under
done
plain-
nothing about. And that, I guess, getting back to your point about the electoral process, which, yeah, we need to absolutely adhere to.
I
giving
recognize
some-
your frustration.
No,
I can
don't-
see it on
no,
your
no.
face.
I'm sorry.
Because you are not implementing what happens in the city. I get it. The problem is, as the state, you are supreme. So if the city's doing something wrong, it is your duty to step in.
Right, so I have two responses to that. First of all, the education context is unique in that local control is important. But I do want to push back and be clear that certainly the Office of the Attorney General takes these issues very seriously. And if there was a discrete policy or action, say for instance, a policy that banned textbooks by African-American authors, this Office of the Attorney General would be the first in line to come to court and seek remedy and redress. But what the complaint alleges here is
But does it have to get to that point? I mean,
give me an
should
example.
children still be learning from textbooks that were printed in 1970, for instance?
Well, the plaintiffs have not alleged that lack of state funding is the cause of their alleged harms. And part of the education article claim, it has to require a causal link to the state. And that's throughout.
Yes, but this is a motion to dismiss, right?
Right, and
So
Painter dismissed at the motion to dismiss stage because there was not a causal link to the state. So that has to be pleaded. And the only thing that's been pleaded about the state is oversight. And I do want to be clear that to seek relief that would compel oversight would be effectively mandamus, which the court, it's well settled that mandamus is not appropriate over discretionary enforcement actions and oversight. The state has discretion in terms of how it performs that responsibility, and that type of relief is not judicially cognizable.
But you're not suggesting that there is no relief that could be devised that might help ameliorate the real problems in our school system.
I could certainly imagine other ways the complaint could have been pled that were not
No.
pleaded.
That wasn't what I asked you. Nice try, though. But that's not what I asked you. I asked you whether there's got to be some ideas amongst the experts in this field of different ways to tweak the system so that we get more equal outcomes.
Well, certainly, I mean, the state,
Right?
the entire framework for their relief is the state education department's education framework, which the state had been developing these things. And the question is whether a court should oversee the implementation of them or the education policy.
Oh, no, but I don't think that's,
experts.
at least that's not what I'm saying, right? My point at the start was that this court has a right to declare that there is a problem and that the constitutional mandate as written in our Constitution has not been met. And
Well-
we certainly have the right to make that declaration and send it back to those of you in power to oversee and create the policy to fix it.
Well, I would agree with the city's response that declaratory relief necessarily entangles the judiciary in the same way that injunctive relief would also entangle the judiciary in these issues.
We're not afraid of being entangled.
Well, the political question doctrine is devised to leave those matters to the state. If there's, I'm happy to answer any other questions about
Anything
the
else?
state's responsibility.
Thank you.
Okay, thank you.
Thank you, Your Honor. May it please the court. James Hassan for interveners. I will I'll try to be brief, but
You've got 5 minutes.
we
so.
agree with the city and the state. that plaintiffs-
Counsel, your brief also begins with the impossibility of remedy. But don't we need to, is that appropriate at this stage of the litigation?
Well, Your Honor, I think the plaintiff's requested relief matters because it tells us about the nature of plaintiff's claims. For example, as we detail on pages 19-20 of our brief, plaintiff's claims are premised on the government's failure to adopt the very measures that they ask for in relief. So in other words, the deficiencies they allege are no different than the requested remedies to address them. They're intertwined. For example, they allege that the city is violating the education article by failing to adopt, quote, best practices for recruiting and retaining teachers. That's at page 75 of the record, paragraph 118. But the relief that they seek for this alleged violation is an injunction ordering the city to adopt those exact hiring and retention practices. Similarly, this is no different from New York State inspection, where the relief that plaintiffs sought there was to have a prison ordered, their claim was that the closure of a prison violated their rights, and the relief that they sought was in order to keep the prison open. They are necessarily intertwined. And I think specific to this case, the question isn't whether the equal protection or education article claims in general are justiciable. The question is whether these particular claims are justiciable.
Let's stop for a moment on the equal protection claim. Do you think that they've made out the necessary scienter in their complaint?
No, I do not, Your Honor. There's no.
What about the persistence of the problems that we're all talking about? Doesn't that give enough of a heads up, at least for the pleading stage?
Well, this court, the Court of Appeals, has required an allegation of intentional discrimination. Here, if you refer to the complaint, there are a lot of allegations that plaintiffs or that the city is aware of something and did not act, or that the city intentionally left its system of education in place or took actions to affect the citywide education system as they must. But there's no allegation of a specific act of discrimination at all. And while we're addressing that point, the relief that the plaintiffs ask for, my friend on the other side referenced the guts of the complaint, and this is from the guts of the complaint. It's paragraph 19. They ask for, quote, race-conscious relief, and in that, an order of race-conscious relief or racial balancing would necessarily conflict with the U.S. Supreme Court's recent decision in SFFA v. Harvard. But to address just a few more issues, Your Honor, you brought up the declaratory judgment question. I would say that this plaintiffs, for the first time in this court, have kind of raised that to rescue the
No, that was in their papers.
It was in their, they requested a declaratory judgment, you're right, in the
Yes.
complaint. They did not argue that it was a reason why the case was justiciable versus, say, an injunction below, was the point that I was making.
Okay.
But more to the point, the Court of Appeals in Morgenthau said that the question for jurisdiction for an injunction and for a declaratory judgment are the same. They use the term coextensive. And on a practical level, it would bring us back to the same point, because the court would still be in a position of, figuring out which books students should be reading in schools, or whether or not that's paragraph 115 of the complaint, page 74 of the record, or page 75.
Or what could happen is that the parties negotiate and a consent agreement is entered into, whereby perhaps some commission is created with people on both sides who are interested, and together they do a review of curriculum, etc. Whatever the plan is, right? But this has been done before. This isn't new. What I suggested is not new. It's been done before.
And what I would say distinguishes this from a case like Klosterman, Your Honor, is the statute required a very discrete thing, which was a plan of a mental health treatment plan for someone discharged. They did not provide it. Here, you would still have to be getting into the day-to-day operations of the school, and we would be back here again after a declaratory judgment, with
You're
new
going to be
litigation.
back here anyway.
It'd be death by 1,000 paper cuts. We'd be in the same place.
So I make jest, but you know what I mean.
Yes, Your Honor. The last thing I would say, if I may,
Yes.
is that the CFE line of cases specifically was about funding, and as my friend from the state mentioned, there's been no allegation here about funding. It's all about day-to-day operations. And for that reason alone, we believe it's non-justiciable.
All right, and I believe you have 2 minutes.
Your Honor, if the court doesn't have any specific questions, I'm pleased to
To rest
leave
on your
that.
brief. Thank you so much.
Thank you. What a pleasure it is to appear in front of this court. Thank you.
All right, we will wait for Justice Oing and the People versus Arthur Strouder.
Good afternoon, Your Honors.
Good afternoon.
And may it please the court, I'm Liza Batkin from the Legal Aid Society representing appellant Arthur Strouder. Mr. Strouder is an 84-year-old man serving time on an invalid plea. We're asking the court to vacate his plea or alternatively reduce his sentence.
Why is it an invalid plea?
Mr. Strouder made 2 statements at his plea allocution that clearly negated his guilt.
And the judge stopped him in his tracks and said, wait a minute, if you are asserting a self-defense and you're saying that you had justification, I will not accept your plea.
That's right.
Right? And he then consulted with counsel.
That's right. And
What's wrong with that?
This court's decision in People versus Cintron shows that that is not enough. It's telling, in fact, how the people tried to distinguish that decision from this one. There, the court had decided that the trial court's inquiry was inadequate, and the people say, oh, well, that's because there was essentially no inquiry in People versus Cintron at all. But if you look closer at that case, the trial court in Cintron told the defendant that given the fact that he had just raised this defense, the case would have to go to trial. Almost indistinguishable from this trial court saying to Mr. Strouder, now that you've raised that defense, I can't take your plea. Also, People versus Cintron, the court gave the defendant an opportunity to speak with his counsel. And yet this court in 2017 held that that wasn't enough. And just as the inquiry in Cintron was inadequate, so was the inquiry here. The court, though, yes, it recognized the problem, it failed to solve the problem. It provided no explanation of what a self-defense claim would have involved, no definition of it. It didn't engage with Mr. Strouder about why he had suggested that he had one. It offloaded that obligation onto defense counsel.
Was that required under the case law? That he go through all of that?
What's required?
I don't believe the case law requires that. It requires it for the judge to stop and make an inquiry, right?
It requires for the court to stop and make an adequate inquiry. And this court has defined an adequate inquiry when someone raises a defense. What makes it adequate is for the court has to determine whether the defendant understood the defense, how it operated, and that the defendant wanted to raise it. And that's from this court's case law in Muniz-Cayetano from 2020. And the court did none of those things.
I disagree. I disagree. He says you can talk with your attorney as long as is necessary. He then reiterated, he said to him, he described the strength of the people's case based on what the court had read, indicated that there was a video that did not necessarily suggest that there was that he was acting in self-defense, and then said, but speak to your attorney and speak to him for as long as you want to, and reiterated, but that if you are claiming this occurred in self-defense, the court will not accept your plea.
Yes, so the court did
Right,
two
and then he
things.
came back to after he talked to his counsel, and there was no mention of justification by the defendant.
Nor by the court. The court never asked Mr. Strouder, okay, so you now understand that you don't have a self-defense claim. The court's inquiry on justification is indistinguishable from the court's inquiry in People versus Cintron, which this court held was inadequate.
I'm sorry, counsel. At that juncture, wasn't the defendant obligated to withdraw his plea?
No, under People versus Lopez, there's no obligation for him to have made a post-allocution for this case to review it, and that's because the trial court had an opportunity to address the problem, which is the justification for the preservation requirement, but the court did so inadequately. And this court in People versus Lawrence held that.
Counsel, you know, I'm looking at Peoples versus Centrum right now.
Yeah.
In that case, in our case here, in that decision, there's no indication whether the court actually told the defendant to go confer with his counsel. This decision doesn't say that. It just said it was inadequate. So in this
Yes.
case, we have a situation where the court actually stopped the proceeding, said, I'm not going any further. You need to talk to your counsel.
I'm referring
big distinction.
I'm referring to the briefs in Cintron, which I cited in.
Well, I'm just looking at the decision. You can cite the briefs, but I'm looking at the decision. And what the decision says, it doesn't mention that the court actually told the defendant, you need to go talk to your counsel.
Well, the decision may not mention it because the decision is rather short, but we looked at the briefs to see what the court, considered an adequate inquiry or an inadequate one. Thank you.
Thank you. You may proceed.
Good afternoon, Your Honors, and may it please the Court, Caroline Williamson for the People. Because the court properly conducted an inquiry to ensure that defendant's plea was knowing, voluntary, and intelligent, defendant's challenge is unpreserved on appeal. Because after the court's remedial action, defendant did not raise any further objection through either a motion to withdraw his plea or a motion to vacate his conviction. He had every opportunity to do so. The plea occurred, and then 3 weeks passed before sentencing, and defendant did not take any of those steps. So we believe that this
And at the time of sentence, did he object and assert a self-defense?
No,
again
he did
during
not. In
sentencing?
fact, he, as referenced by defense counsel in their briefs, he accepted responsibility for his actions and expressed remorse. So he never again raised any issues with his plea. He didn't at any time. So during the plea proceeding, we would just like to note that this case is completely distinguishable from Cintron because we also looked at the briefs, and what the court said in response to defendant was actually, after defendant said he never possessed anything, the judge said, well, then this case has to go to trial, okay? The 6-year offer, as I understand it, will be pulled by the people if we go forward. And then the defendant interjected that he wanted to ask the judge a question, and the judge said, you can talk to your lawyer. And so he actually not only did not explain you raised a affirmative defense, he rejected defendant's opportunity question if he could
Request
inquire
him
further.
to speak.
Yes. So that is completely different. And we'd also like to note that not only did the court here give defendant the opportunity to speak with his attorney after he made the statements during his allocution, but the court also opened the plea allocution by asking defendant whether he had had the opportunity to speak with his counsel and discuss all possible defenses that counsel would raise in this case, and defendant said that he had. And he never said that he'd had ineffective assistance of counsel or said that that had not occurred. We also believe that reference to the totality of circumstances is very important when determining whether a plea was knowing involuntary. And in this case, it's very clear that this wasn't a rushed process. Defendant had been appearing before this court for months before this had happened. The court had been present during some of the plea negotiations, and there'd never been any inference that there had been self-defense.
And this was not the defendant's first interaction with the criminal justice system.
It was not. He has a rather long record. And the fact that he is, just to reference the sentencing question, the fact that he is old now isn't really relevant in this scenario because he was in his 80s when he followed his neighbor into an elevator and stabbed him 6 times. So we don't think that his age makes him any less of a risk to society and shouldn't really be a consideration. If there are no further questions.
Thank you.
I have one further question. Given that he was so old and given that this was a not assisted living, but it was
It's a senior living facility.
I mean, should the court have had some obligation to look into competency? I gather there's no record about whether he was incompetent or not, but did the court have an affirmative duty to look into whether there was senility involved or other kind of mental incapacity?
I think that that falls into the fact that the court asked whether he had discussed with counsel any potential defenses, and I think it's counsel's obligation to raise that potential defense. And as noted in the record, this was a long proceeding over several months, and No one ever raised that, so we don't think that it's relevant in these circumstances. Thank you.
Thank you.
Oh, no problem. As for my friend on the other side's reference to the totality of the circumstances, Lopez applies to a very specific and rare circumstance where the defendant makes guilt-negating statements on the record and where the court fails to adequately address them, regardless of the surrounding circumstances of the plea. But even so, there was a reference to Mr. Strotter's long record. In fact, the last time he went to court was 20 years ago for a drug offense. 30 years ago, he had another drug offense, and before that, his last crimes were in 1960 and 1983. This man has lived a very long life, and, given the length—
My point in asking that question was simply that he would have understood that if the judge was not taking the plea, then the menu in criminal justice system is rather small, okay? So you either take a plea or you go to trial. No plea, you're going to trial. So that he understood that is my point.
Yes, but he did not understand what was involved for a self-defense defense because he had never before been in court on a crime that would have allowed him to raise a self-defense. And just last point is that as to the excessive sentence, it simply doesn't serve justice or the city's resources for Mr. Strotter to stay in prison until he is 89 years old and on post-release supervision into his mid-90s. Thank you very much.
Thank you. Romeo C. and Remy C. You may proceed.
Good late afternoon, Your Honors. Karen Wolf for the appellant, ACS, if it pleases the court. This case involves two very young children who were effectively released to their respondent mother just 5 weeks after a neglect finding was entered, wherein the family court, the same judge, found that the mother was in fact an impairment, an imminent impairment to the children's health, welfare, and safety. A derivative finding of neglect was entered on behalf of the elder child. The respondent mother, unfortunately, has never acknowledged her drug addiction and has never taken any steps to address it. And we find ourselves in the same position at the dispositional hearing and the first permanency hearing as we were at the conclusion of the fact finding. The youngest child was born with a severe methadone addiction. The child, unfortunately, was required to remain in the NICU for 44 days before the child could be released. The mother has never acknowledged that she had any sort of drug problem. In fact, at the dispositional hearing, she maintained her testimony, as she had during the fact-finding proceeding, that she had not intentionally or willfully ingested.
Somebody gave her that by mistake instead of Tylenol. Yeah, we saw.
Her sister's boyfriend. Yes, right? Your Honor. Notwithstanding the very egregious findings that came from that testimony, the mother still lacked insight into her possible addiction and has not attended any services and only infrequently attends drug screenings at her convenience.
Your position is essentially that the mother should be excluded. There should be the mother shouldn't be present at all when your position is the father, should have custody of the children, correct?
She should have supervised visits.
Supervised visitations, yes. We would request that the family court order be reversed and that the mother be excluded from the home at the time of the dispositional hearing. The parents still resided together, and that the mother have supervised visitation. The paternal grandmother, I believe she's actually a paternal great aunt, is available for supervised visitation. The father agreed to this result, and this is also supported by the attorney for the children.
Okay, thank you.
Thank you.
May it please the court, Saul Zipkin, Bronx Defenders, for the respondent mother, Perla P. This case was before the family court for a long time, almost 3 years. And during that long period, ACS never once identified any safety concerns for the child at visits, when inspecting the home.
Although the one concern is that they kept on asking her to submit to drug tests, 15 of them, and she only attended 4 of them, 2 of which are kind of inconclusive, or one still had not, one report by the time of the writings had not yielded a report yet, so I don't know what happened there, but 4 out of 15 is not exactly compliance and doesn't exactly inspire confidence.
And did she engage in any of the recommended services?
So to answer both of those, the family court considered all of that in its decision. And again, just to step back, this particular family court judge was in this case for 2.5 years roughly, so really knew this family. And first, the family court credited Ms. P's explanation for some of the ones she missed. She was sick at one point, she had conjunctivitis, she had COVID, she had RSV, she had a surgery procedure, and the family court credited, in general, a number of her points. But in addition to that, she completed services, parenting, and such things. She went to drug counseling and didn't finish the program because she had a conflict with her. She testified that she had a conflict with the counselor she was working with, and the organization, the program said she could have a new coordinator and working with someone else, but that never came together. But in general, the point is that this is a family and the mother who'd been through this whole years with the family court and had never tested, maybe not every time, certainly, but every time tested was negative, did everything else. ACS never had one concern the entire time. The children are well bonded to her. The visits have all gone well. There's been good testimony about that, a significant amount of testimony. And frankly, that is what ACS is saying. Let me put it this way. What ACS is saying is that we don't know. There's been no evidence of any drug use or anything since the filing of the petition. And it's been close to—
When was the last drug test she took? I mean, that argument is as good as the last drug test, right? So if the last drug test was 2 years ago, that does not give me insight and comfort that I can allow this child to be with her mother by herself.
So at the time of, just to respond to that, at the time of the dispositional hearing and dispositional determination, which was, I have this, June 24th, she had the last negative test, which was the last test, was roughly a month earlier, May 12th.
Of what year?
What?
Of what year?
Yes, I mean,
Of which year? I'm asking you the year.
2023,
Okay.
just now. And she had had a procedure which caused her to miss, I believe, the last 2 or 3, whatever it was, after that, before. But it had been a month, and she went to multiple procedures, multiple drug tests, and tested negative 13 times in the 8 months prior to the dispositional.
Where is that in the record?
It was—
I saw 15 requests and only 4 taken. So 13 negative? Where
So
is
this
that in the
was the
record?
permanency report that was dated June 20-something, 2023.
But is that in the record?
Yes, it is.
Okay.
It's the
It is in the
smaller—
record?
Yes, it's,
Okay.
I think, record number 11 or 12. It's not the 800-page record, it's the 30-page record,
Okay.
the materials that came in as evidence at disposition. So there were a number of tests, and this is where the judge credited her statements about the health issues she had had, particularly in the early part of 2023, and why she had missed a number of tests. But in any event, just to flag, and I see my time is up, ACS is saying we don't know. We don't know. Maybe she's using drugs. We don't know. And in the face of all this evidence that there have been no issues in the last 3 years, we don't know is not enough. And in ACS's argument would mean that the children never went back to their mother if she continued missing tests for whatever reason. And that's not in the children's best interest. I don't think there's any plausible argument that we don't know whether she might is a good reason to keep these children away from their mother who they're bonded with as they grow up.
All right.
But it's not keeping her away, right? They're offering supervised visits through maternal grandmother.
So it's not keeping her like full away, but it's limited, right? As of now, because of the stay, the children are still with the grandmother who lives in the Bronx, and she lives in New Jersey. And the grandmother comes in on weekends, so she spends time with the children on weekends. This obviously is not in the record, but this is recent. And she sometimes comes in herself to the Bronx, has video type visits when her work allows. So she, yes, is absolutely not permanently.
Well, I'm going to take a look back at the record because I didn't see what you referenced.
Okay, terrific.
Counsel, you have a minute.
Thank you, Your Honors. Just to point the court to the point in the record, which may be of assistance, this is the dispositional hearing. The hearing is from 6/14/2023. It's also in the record, and this is the testimony of the foster care service provider beginning on pages 17, going to 18, and through to 19. And then on pages 22 and 26, we pick up the testimony of the respondent mother herself, wherein she demonstrates that she has in fact not been attending the drug screenings. I am unaware of 8 negative drug screenings immediately prior to a
So this may have been after the dispositional hearing?
I'm sorry, Your Honor.
This may be he may be referring to evidence that's after the post-dispositional hearing.
If I may update the court, if that is in fact what counsel is referring to, I have been informed differently.
Okay.
They're not referring to after this.
All right. We will look at the record. Thank you. All right.
Thank you, Your Honors.
Thank you both. Chan versus Havermeyer Holdings.
Good afternoon. May it please the court. Jeff Crockett for appellants. We are challenging the dismissal on a motion to dismiss of the 4 plaintiffs' fraud claims. Taking the facts in the light most favorable to our clients, as of course you must do, they were collectively induced by fraud to put $3.1 million into an LLC by defendants who had a fiduciary duty to them and were presented a false and misleading presentation as to the finances of the business. And in
Counsel, this may be a little granular, but Mr. Fu didn't sign his subscription agreement until June, and at that time he knew that the refinancing had not been secured. So does that undermine any claim of reliance on his part?
No, Your Honor. What I would say, because he had sent the money in reliance on the representations, that was a significant fact. If he hadn't signed the agreement,
He sent the money prior to signing the subscription agreement, and that's what's crucial. Okay.
yes, yeah, he sent at the same time in this March time period, and he just never got around to signing the paperwork. I think, and of all the misrepresentations, the one that is the most glaring, of course, is the refinancing is already done. In response to, is there any chance that this refinancing didn't happen? No, it's already done. And of course,
This is all flowing from Nicholas Silvers, or Colin Rankowitz, right? They're the
Yes,
ones who have
correct.
sort of
Exactly.
spearheading getting the investors or getting the folks to put more money in.
Correct. And the plaintiffs were told very specific facts about this refinancing. It was going to save $9 million. The interest rate was 4.2% less. There were 2 extensions. All of that was made up. There was no refinancing. There was no commitment. There was no contract. There was not even a handshake. Now, some of that we discovered later, but we do allege it was a false statement, and clearly it was a false statement.
But you got to get around the merger clause in the subscription agreement, which you do via
And
creation of fiduciary.
and that's of all the arguments that they raised, and they raised the kitchen sink of attacks on every element of every count. The only thing the court went with them on was the disclaimer. Okay, and I want to.
But that disclaimer doesn't, depending on your argument is, well, we don't need the disclaimer doesn't bar us because we have a fiduciary duty
Correct.
that gets around the disclaimer, right?
Exactly. That's one of three answers. There's a fiduciary duty, so we cited a number of cases in that situation, unless it's a very specific disclaimer that says, listen, this is me, you paying money that otherwise I would have to pay, and I want you to understand that. That didn't happen.
Right.
That was the facts, but that wasn't disclosed.
But UCA is different than FEW, right? UCA.
Yes, correct.
Different, because they're newer.
Yes, they have the fiduciary duty there there was not a pre-existing LLC managing member relationship, but we say there's a fiduciary duty as promoters of the LLC to potential investors under the Roney versus
Your
Arthur
stronger
case.
argument is the individual plaintiffs. Those guys were definitely part of the transaction.
Yes, yes, and although
Plaintiff Yucca did sign the subscription agreement, yes?
absolutely, absolutely, and what happened there, that this is
And that agreement does represent that everything you can't rely on anything else except what's in this agreement, correct?
it doesn't say that. What it says you can't rely on anything except the offering materials, and that's ambiguous. Did that mean what they really told me about this investment, or did that mean?
No, that kind of language exists in almost all offerings, and that is not what it means.
Yes, no, I understand. Okay, well, I want to say that
That is not what it means.
The clearest way to reverse the trial court on the disclaimer issue is this court in basis clearly said you cannot, a disclaimer does not address something within the peculiar knowledge of the defendants. The complaint alleges this refinancing, which of course was at that point a discussion between the defendants and the bank, was in their peculiar knowledge, which that's the
Couldn't
facts.
the plaintiffs have asked at some point who's doing the refinancing? That was sort of an interesting omission, I think.
I think there will ultimately be fact issues on what should have been asked and what shouldn't have been asked. But what we allege is that we trusted them. You know, fiduciary duty means you can trust them without inquiry. We certainly don't have to say, well, you're telling me this, I think you're lying. What they were assured is, we have a deal. We have a done deal, and we know the terms. And I think in the context of the discussion, it means stop asking me about it. It's done. Just be assured.
It's only one remark. The remark was, it's already done.
Correct.
That's it. I mean, I keep remembering that phrase.
Exactly. So I'll save the rest of my time.
You'll have time on rebuttal.
Good afternoon. May it please the court, David Lackowitz with Moses Singer. I'd like to pick up where Judge Oing left off, which is their entire case revolves around this allegation that they were told that this $230 million refinancing was already done. The chronology is critical here. On February
Are you saying they
27th
weren't told that?
Well, for present purposes, I need to acknowledge that they were told because
Okay.
this is a motion to dismiss. So for purposes of today, we don't contest whether or not it was said or wasn't.
All right.
On February 27th, which is a Thursday, these individual plaintiffs received a formal, official, written investor update that was sent to all members of this company, in which it expressly said that they were working on a refinancing, which they hoped would close in Q2. In other words, not for weeks. Then, apparently, according to the
At the
complaint—
time that was done, it was Q1, right?
Yes, ma'am.
So Q2
That was
is
February.
like
So
right around the corner.
They're saying best case scenario, April, which is, let's say, around 4 or 5 weeks from then. Then there's this March call 2 business days later, in which they're talking about the contours of the deal, and allegedly Mr. Silver refers to the financing as already done. Then 4 days after that, in writing, the defendants again confirmed that this refinancing was not in fact done, and expressly referenced the refinancing as, quote, something we are putting in place now. There was no doubt that these individual plaintiffs knew that this refinancing was not done, but was only a prospective refinance.
What about the March 3rd communication from Rankowitz with the spreadsheet that made it, I gather, I mean, arguably, made it look like the refinance loan was complete already? I mean, do you disagree with that?
The memo, yeah.
The model is strictly prospective. It's talking about what the refinancing will look like in the event that it closes. The other thing I would say is, even assuming for the moment that my client had fiduciary obligations to these plaintiffs, and we recognize that there is a fiduciary duty owed by TC Haven.
According to the email of March 3rd, I have to go back, the refinance model showed the opportunity using a capital structure, financing rate, and debt maturity consistent with a refinance loan that was complete already. The refinance model contained no scenarios or projections in which the refinancing was not yet complete.
What they were referring to is the terms were similar to
They
terms.
sent a memo trying to leave the impression that it was done, consistent with the lie they told. That's what we have here.
I respectfully disagree, Your Honor. I think that these individuals, in particular, given their level of sophistication, in particular, given the
Except that
disclaimer language.
when we're dealing with a fiduciary duty, you have a problem there.
So I want to talk about the fiduciary duty for a moment. As I started to say, there is no doubt T.C. Havemeyer owes a fiduciary duty to the company and its members. There are limits to that fiduciary duty. This was an arm's length transaction between sophisticated individuals, and the fiduciary duty does not extend to that transaction.
Well, the transaction could also be defined as like the dime, right? The real estate, wasn't that the name of this thing? Yeah.
Dime is the name of
In
the
other words, the real
construction.
estate development project was the relevant globe in which the fiduciary duty was operative.
Yes, this financing undeniably concerned the same project. I would suggest it's a very slippery slope. What if, for instance, one of these individual plaintiffs happens to have had an engineering company that was retained by the manager to help perform engineering services in connection with the construction project? Arm's length transaction between sophisticated parties, clearly the fiduciary duty wouldn't extend there. I think if this
I don't know
court-
about that. You say that, but I don't
Well,
know about that.
Notably, the crux of their case is we were their fiduciaries, notwithstanding.
The crux of their case is that Havemeyer had material information that he did not disclose, and they relied on that information to their detriment. They invested in something that was not as secure as Havemeyer painted it to be.
Your Honor, when they were told 2 business days before in writing that there's no way this loan is going to close, and this is not.
What day was it that they were told? What day were they told?
That was
This-
February 27th. That was the Thursday before the March call, 2 business days before. And then that email was circulated again the subsequent day. When these investors were told in writing, this will not close until at best, at the earliest, 5 weeks from now. And then mere days after this alleged misrepresentation, they're told again that it hasn't closed. They have a heightened duty.
Hold on a second. The dates to me are very important. On February 28th,
February 27th.
That this deal or this refinancing deal is not going to close for another 5 weeks, you said?
Yes, until
So
at
that-
most Q2.
So that would take you into March, at the end, let's say March 31st?
I would have said April 1st, but.
April 1st, okay, April 1st.
And that's in the record of 243.
So at that point, in my notes here, the investments, the monies came in. One came in for $660,000 on March 16th. Another came in at around March 4th. Another came in on March 11th. You're shaking your head. That didn't happen?
No, those are the dates that certain of the plaintiffs signed their subscription agreements. The payments were made on the 10th and the 11th. In other words,
Of March?
Of March.
Okay.
But
Money was coming in, though.
the money came in, so the very brief chronology was February 27th. They are told Q2.
Q2, right.
That's Thursday. On Tuesday of the next week is the March call that they complain about. On Friday, they are told in writing it hasn't closed, and they refer to the refinancing as one that they were, quote, putting in place now. Subsequent to that, they invest.
Except that on March 11th, when Fu emailed Rankowitz and Silvers to inform them that he had wired his $1 million investment and noted the possibility of a short-term liquidity crunch given the state of the financial markets due to the pandemic, Fu observed, "Great that you've refinanced this loan already." And Silver gave no indication. Instead of responding, "No, it's not done yet. You're wrong. Your impression is wrong," he gave no indication that the refinancing was not done.
That's correct. That email was sent after they had invested. And so it can't possibly form the basis for a fraud claim, respectfully, or rescission or negligent misrepresentation. Their monies were in already.
Okay. All right.
Thank you, Your Honor.
3 brief points. First of all, there's a distinction between the loan has already closed from the bank has committed to make the loan 3 weeks later. We were told the latter. Second,
The fact that a loan has not closed doesn't mean that there isn't an agreement for the
Absolutely.
refinancing, right?
correct.
Maybe somebody got sick and they couldn't attend the closing. It could be a whole host of things.
And here, there wasn't even a handshake with the bank. But second point, what the court mentioned about great, it's done already. One of the things that a party with superior knowledge, even if not a fiduciary, has to correct a misimpression. That didn't happen here, and that applies to Yucca as well as the other three plaintiffs. And the third point, I just want to quote from the Dubé-Foreman case on a disclaimer in a fiduciary situation. This is the third department case that we cite. Contrary to, it says, a specific disclaimer clause cannot serve to defeat a claim of fraud if the seller owes the buyer a fiduciary duty, but nonetheless breaches that duty by failing to disclose any information that could reasonably bear on the buyer's consideration. That's right on point. That's 6183D 1255 Dubé-Foreman from 2009. Thank you. If there's no further questions.
Thank you so much. Williams versus, oh, 2 minutes, I forgot. Hold on, he has 2 more minutes.
Thank you, Your Honor. I get the sense that I'm swimming upstream a little bit, so I just want to try to pivot and focus the court on the different elements of these claims. So, for instance, with respect to the fraud and rescission claim, they must allege scienter. There is nothing in the complaint that says that they were purposefully deceived. There is nothing in the complaint that alleges that my clients knew or had any reason to believe that this loan would not close. There was
no loan, right? There was no refinancing.
Well, the reality is
that you wanted to refinance doesn't equal we intended to. That's not the way this works.
But that's exactly respectfully what they were told, Your Honor, that this refinance is going to close, if we're lucky, in April.
They were told it was already done.
Your Honor, we cite to a case in which the defendants represented that an IPO offering was, quote, a done deal and was a sure thing. And the court there concluded that those representations were not representations of present fact, but rather expectations of future hopes. In other words, we're putting this in place now.
No, your client said the refinancing is done, meaning it has already been approved. The bank has already signed off on it, etc. Okay? That's what that means.
But respectfully, they didn't say there's a signed agreement, and they didn't say the bank has signed off on it. They told them in writing, we're putting this together. In our mind, this is as good as done. They couldn't predict that 3 days later, the pandemic would shut the city down and irreparably change commercial real estate in the city. They were simply reinforcing.
In March, the city shut down on February 13th.
My recollection was March 15th.
I know, I was in this court. It was shut down on February 13th. So, sorry.
The court has no further questions.
Williams versus Plaxel. You've got 5 minutes.
Thank you. Good afternoon, Your Honors. My name is Jason Steinberg. I represent the plaintiff appellant in this matter. So this is the 4th time we are arguing the issues in this case. The first time we argued this was back in 2019 in front of Judge Ruiz. In that motion, the defendant, Plaxel Realty, who was still in the case, argued that it was an out-of-possession owner and that they were not liable for any of the injuries or the accident itself. And Judge Ruiz decided that issue, and we opposed that motion, arguing that there are issues of fact as to the ownership of the premises. In the papers, they tried to argue that the owner of the property is a company that was not in the case yet, Plaxel Inc. There's Plaxel Realty, and then there's Plaxel Inc. So they said, no, the ownership of the building itself is Plaxel Inc. We own the land. That's all they said. That's the only thing they argued in those papers. In opposition, we said, well, there is a fact as to ownership, and in fact, whether or not those two entities are one and the same. This was based upon the deposition testimony primarily of the witness, who's the managing director of both corporations. So after we presented issues of fact, primarily the question of ownership, and whether or not they're the same entity based upon the testimony of the managing director saying, he manages both properties, has no idea how the taxes are paid, has no idea how insurance is paid.
You're not leaving much time for the argument on this case.
Sorry?
You're giving us get to this issue, the issue of out of possession.
Well, if they're one and the same entity, then the issue was effectively determined in the first motion by Judge Ruiz when she held there issues of fact as to ownership of the property. Part of our argument was that they were both the same entity, Plaxel Inc. and Plaxel Realty. And in the first motion, when we cross-moved to amend the complaint to add Plaxel Inc. to the case, and the attorney for Plaxel Realty opposed it on behalf of Plaxel Inc. All right? So they have common ownership, the same owners, it's a family-owned business. They sold the property to each other under this, sale of, yeah.
But I think what my colleague is asking you is, you're here before us to determine why your complaint why your action should be reinstated. It was dismissed because the court determined as a matter of law that there was no basis for liability, correct?
Yeah, well.
So isn't that
okay.
the heart of why you're here? I mean.
Maybe I talked too much about the first, okay.
Dealing with the garage.
All right.
You cite a boatload of regulations by your expert that have nothing to do with the garage. Garda really, as I understand the fact pattern, was directing the truck backwards into the bay in which your client sitting on a chair in the back of the truck.
It's an armored truck.
Still wrapping my head around.
The reason
Why are we here? Why do you believe the complaint is still alive?
Because the law of the case precluded the judge from deciding the issues, whether or not the statutes were violated, et cetera, because that was determined in the first motion. We specifically argued in the first motion in front of Judge Ruiz, we specifically...
But I need you to understand that we are only considering the decision below, the current decision below.
And we argued in this particular brief, we specifically argued the law of the case, saying that the judge should have just outright denied the motion on the grounds of a law of the case based upon the prior determination by Judge Ruiz, specifically holding that there are issues of fact with respect to the ownership and, of course, whether or not the
If we disagree with that, what else do you argue?
Okay, all right. Well, there's an issue of fact as to whether or not the statute was violated. Our expert specifically concluded that there was a violation of the building code. This was with respect to, this is a corridor, and there was an obstruction
The
preventing
truck bay
access.
is a corridor?
Sorry?
The truck bay?
Yes.
Where trucks back up to deliver is a corridor?
That's correct. That's what the building code specifically, it says, it doesn't limit it. They're trying to say that this is restricted only to pedestrians. The statute doesn't say that. It just says it's a corridor, it's a passageway open to an exit. That's all it says. All right, so our expert found that there was a violation of that particular statute and the lighting statute, of course, because it was dark. But again, on a motion for summary judgment, it's not my burden to affirmatively establish that there was a violation of the statute. That was their burden. They had to do that. Okay, they had to state there was no violation of any statute, and they failed to demonstrate that, especially with respect to the lighting issue. Because this is based upon an expert who conducted an inspection of the property 9 years after the accident happened, and he said, oh, the lighting was fine. How could he possibly conclude that there was no violation of the lighting statute when he has no idea what the circumstances were back at the time of the accident, and my client said it was dark? Okay. So I think they did not establish a prima facie case that there was no violation of the two statutes. And again, I know it's a broken record. Law of the case precludes a decision on those issues.
Okay. Thank you. You'll have time on rebuttal. Counsel.
Good afternoon.
Good afternoon.
May it please the court. Patrick Lawless for the defendant respondent Plaxall. First of all, Plaxall is a separate corporate entity than Realty Sub. They're entitled to their own defenses, and they were entitled to move for summary judgment. With respect to the summary judgment motion, Plaxall demonstrated that none of the alleged building code violations by the plaintiff are applicable to this case. As Your Honor just stated, this isn't a corridor, it's a trucking bay. Right. All the statutes that the plaintiff cites to specifically relate to corridors, and there's a definition in the building code of what a corridor is, and it's clearly not this trucking bay. And so none of these statutes apply. And on top of that, Plaxall was able to demonstrate that there was nothing wrong with this building. With respect to the lighting issue, apart from the fact that the lighting statute specifically dealt with corridors, which isn't applicable, Plaxel's expert, who inspected it after Plaxel was brought into the case, inspected the corridor and said that there was nothing wrong with the lighting. The plaintiff's own expert never refuted that. The plaintiff's expert performed his own inspection in 2015, 4 years after the accident. He said the plaintiff accompanied him to this inspection and said that it was in the same condition as the date of the alleged accident. But conspicuously absent from the expert's affidavit is his own personal observations of the lighting conditions. He just states in conclusory fashion that the lighting caused the accident without relating his own observations as to what the lighting conditions were during that inspection. Okay. So in light of the foregoing, the court below properly granted Plaxel's motion for summary judgment.
Thank you.
Thank you.
Okay, you have 1 minute.
I mean, again, I can only reiterate that it's their motion for summary judgment, his burden to establish that there's no statutory violations, and you have conflicting expert testimony as to which statute, what the statutes mean, whether they apply. That should have been enough to deny the summary judgment motion. But again, I understand that there might be a disagreement, but these issues were already decided. I'll just keep saying it.
Thank you so much. You have a good night. All right. Perry versus SADA 3.
May I proceed, Your Honor?
Yes, you may.
Good afternoon, Your Honors. May it please the court. My name is Michael Altman. I'm with the Altman Law Firm, appellate counsel for Mr. Perry. I want to address 3 issues. First issue I want to address is the dismissal of Mr. Perry's handrail claim, which we submit was manifest error. The motion court did not discuss the handrail claim at all in its decision, when it dismissed Mr. Perry's claim. And we submit that the court's error is established in just 2 pages of the record. The plaintiff's expert opined that the code mandating a handrail was applicable and was violated. That's at page 372 of the record. At his deposition, Mr. Perry testified that he reached out as he fell, but there was nothing there and nothing to grab onto.
Defendant argues that the injury had already happened by the time he reached out for the handrail, and so therefore the handrail is a non-issue. He was already injured.
Right, well, there's no medical evidence that that's the case. That's counsel's lay perception, and counsel will certainly be able
Based on
to
his description of how, based on the plaintiff's description of how he fell and hear the pop.
Right, he turned his ankle and it popped, and then he fell and he hit the ground, and now he has a very serious fracture that required surgery. There's no evidence in the record that would lead a court to find as a matter of law that the only injuries he sustained were when he twisted his ankle. And as I mentioned in my brief, there's no threshold here for an injury. If he exacerbated, if it made the fracture worse, that's enough to sustain his claim. And this court's precedent, I cited 5 cases at pages 23 and 24 of the record, show that when there's no handrail there and a plaintiff reaches for a handrail, they have a handrail claim. Now, certainly, at trial, plaintiff will have the burden of demonstrating what injuries were caused by defendant's negligence, and with respect to the handrail claim, plaintiff will have that burden at trial. But plaintiff doesn't have that burden now. Plaintiff has alleged that he was injured as a result of the fall, and I'm not aware of any case that has held that counsel's lay opinion as to when the injuries were sustained or not sustained is a basis for non-suiting a plaintiff.
What's your position? Let me restate it. These steps, or this stair, the trapezoid stair, an issue, was part of the building for decades. This was not a new step.
Correct.
So because grandfathered in that context, the argument is being made that the 2014 codes don't apply. You don't agree with that?
No, I don't agree with that. We have an expert. The expert opined, I think it's at page 3. 75 of the record that good practice is to bring your buildings up to code. Now, with respect to handrail, I'm not, defendants or respondents, excuse me, never argued that the handrail code was inapplicable. So if you, I do want to distinguish between the stair and the handrail. They have never argued that the handrail, that the code did not require a handrail. With respect to the stair.
So your position is that the stair didn't have to be 44 inches? I mean.
No, my
it had to be
position is
40
that it was required to be 44 inches. There's expert evidence that it was required to be 44 inches, and there is no evidence to the contrary. No one has come forward and said that that was not required. I understand if there was an expert who came in and said, this is not the applicable building code, there's a different applicable building code, that would then maybe we have a battle of experts, so I'd still get to a jury, but we don't even have that. There's no evidence in the record that these codes are not applicable. And not only, again, at 375, does the expert say that the codes are applicable, but also that there was a common law duty to do that, which is an entirely separate issue. So even were the codes not applicable, there's still expert evidence that they had a common law duty to make the stairs safe. With respect to the court's finding that the defects were not tied in to how Mr. Perry was hurt, at pages 111 to 113 of the record, he explained.
Can you address the issue of the court's finding that this was an open and obvious defect?
Sure. The court
Or
found
I should say, according to the judge, open and obvious, dangerous defect.
Well, he didn't find that it was inherent. The court didn't find that it was inherently dangerous. The court found that it was open and obvious and dismissed on that basis. But this court's precedent makes clear that there also has to be a finding that it's not inherently dangerous. There's expert testimony that it's inherently dangerous. I know my time's up, but I know that in cases like this, that it's the eye test that matters. So I just ask you to look at the pictures where you have close-ups.
We have, and you have time on rebuttal.
Very
okay?
good. Thank you, Your Honor.
Who's next?
Good afternoon, Your Honor. I'm Kimberly Miller with the Law Office of Kevin Westerman for the defendants, SATA 3 and Empelon El Pastor. We believe the court below correctly granted defendants SATA 3 and Empelon's motion for summary judgment. Empelon and SATA 3 were the restaurant tenant. They made no changes to the subject steps, which is shown through the certified Department of Building plans that were submitted. The lease between Empelon and St. Mark's did not require Empelon to make any structural repairs to the building, and therefore Empelon had no responsibility regarding the steps pursuant to the lease outside of keeping the steps clear of debris, and plaintiff did not claim there was any debris on the steps.
Go ahead.
I was going to say, does that renovation in 2014 or something make applicable the building codes?
No, it was not.
Why not?
A significant structural change to the building that it would take it into the code that was current at that particular time. And
What was the
would
renovation?
It was in 2014.
What was the renovation?
There had been a restaurant within the tenancy before that. My client was also a restaurant, and they moved in. It was like a restaurant bar situation. So there were no
What was renovated? What was
major.
Was it a complete remodel of the restaurant
No,
to make it look better?
It was a tequila bar, so it was like banquettes and things like that.
And so
it
all
was-
of that got taken out in order to create a normal dining floor.
Exactly, and
Okay.
it would not have taken it into a different building code. It wasn't a significant alteration to the building. So that would also not require Empelon to have made any.
Was
structural
it Emblon who put the strips on the step
We
so
did.
that that step would be, I'm assuming they did that
It's a
so that.
non-slip step.
So that people would not slip off the step? Because they did changed the step in that they put new tiles on the step, as I read the record.
Structurally change the steps. They just put on something that made them safer. So that was.
That begs the question, right?
Well, it made it safer, hopefully. I mean, no one else had ever had any accidents on those.
That's not required, though, is it?
I'm sorry, what?
That is not a requirement.
No,
Right.
it was not a requirement. It was something that they chose to do.
Now,
Also-
an open and obvious, the finding by the court that this was open and obvious and therefore the defendants were not liable, isn't that construct not in keeping with our precedent in this department that open and obvious goes to the duty to warn?
Open and obvious.
And then becomes an issue for comparative negligence, perhaps, that something that was open and obvious you didn't see, and so maybe you're partly responsible for your own fault, but that doesn't relieve a landowner of responsibility.
But we're not a landowner.
Okay.
We're simply a tenant, and a tenant would not be responsible for design defects that were already there, that were the responsibility of the landowner.
Okay.
Also, I just wanted to note that plaintiff in its reply brief only states in its motion segment 4 that its motion for summary judgment against the owners should be granted and not my tenant, Emplan.
Okay.
Pastor. Thank you very much.
Thank you. All right. Counsel?
Good afternoon. Thomas Fogarty from Kieran and Trebach for the remaining defendants' respondents. I'll be brief, both the panel and...
So why don't you start where she left off? The open and obvious only goes to the duty to warn and does not alleviate a property owner of its duty. So why should this court affirm the finding of the court below that because there was an open and obvious condition that you're not liable?
Well, initially, just to correct plaintiff's interpretation of...
Please answer my question first.
Oh, sure. If you look at Baker, if you look at Miles, open and obvious is a complete defense. It's not just comparative.
No, it's not a complete defense. Not the way you're saying. And what I've just said is the state of the law.
We feel that there's, a case law in our brief to the opposite, but regardless of whether it was regardless of whether it's open and obvious, the court also held that it wasn't the proximate cause of the plaintiff's incident.
And what was the proximate cause of the plaintiff's accident if it wasn't that his ankle rolled off this trapezoid step?
Sure, no, look, every time you fall down, it's not necessarily somebody else's fault. I understand he's with his friend, he's embarrassed, he's looking for a payday, but just because he misstepped and rolled his ankle doesn't mean that it was because
the man
stairs
broke
were
his
designed
ankle.
the way they were.
Okay, so this isn't, I have a little boo-boo and I'm running to the courthouse. So please be more respectful.
I'm sorry, Your Honor, I didn't mean any disrespect.
I mean, you have a right to make your argument. You don't have to denigrate the plaintiff to do it, all right?
Sorry.
Okay, so explain to me why his claims that when he attempted to step down from the step that his foot, because it wasn't a full step, kind of slid off and twisted and popped, causing a fracture to his ankle that required surgery, I believe.
Sure, I mean, the step was obviously big enough for people to go down it all the time without getting injured. He wasn't looking down where he was stepping. He half missed the step and rolled his ankle.
Okay, anything else?
I have one question, which is, Empellon says that your indemnity claim should be dismissed, common law and contractual, and you didn't really respond to that in the brief. Do you want to say anything about that?
Yeah, no, under the lease, we are entitled to indemnification. The court didn't rule on it, holding that it was moot because the plaintiff's action was dismissed. So that's why it wasn't addressed.
Okay.
Yeah, the only other thing I wanted to say was that, you don't need to be a doctor to know that the plaintiff was injured rolling his ankle, not in the fall subsequent. It's not like a back or a neck injury that would have happened because he fell, because there was no handrail. In fact, because he fell, it would have taken...
Are you, wait, your argument seems to suggest that he had to have broken his ankle when he fell. And that's just not an accurate statement.
If it was due to a lack of a handrail.
If the step was constructed in such a way that it was dangerous to him, and because of it, his foot slipped off and it popped, the fact that he also fell just added insult to the injury, but doesn't change the equation.
Yeah, I was only referring to the handrail claim, Your Honor.
Okay, all right. Anything else?
Nope, thanks.
Thank you. And you have time on rebuttal.
Thank you, Your Honor. I just want to briefly mention 2 points. Both my adversaries mentioned that there were no prior incidents. Neither defendant kept records of prior incidents, so all you know is that the 2 witnesses who testified weren't aware of prior incidents. There's no evidence that there were no prior incidents. Getting back to the open, obvious, and inherently dangerous issue, I just want to touch on this court's decision in Maja Zahara at 191 AD 3rd 605, where this court held that defendants failed to meet their initial burden of showing that the bakery's exterior steps were open, obvious, and not inherently dangerous because, and I quote, there are no photographs in the record that show how the exterior steps would appear to a pedestrian, such as plaintiff when exiting the store. It's the exact same situation here. There are no photographs in the record showing what Mr. Perry would have seen as he left. So they never met an initial burden of showing.
Photographs are pointing to the, instead of going
They're
out.
showing the entrance, not the exit, what he would have seen.
Okay.
There's no way. Thank you, Your Honor.
Thank you. Perry versus, that was Perry, right? Yeah. People versus Joshua Feliciano.
Thought I might have to represent someone else for a second there, Your Honor.
It's late, I'm sorry. Okay.
Good afternoon or evening, and may it please the court, Danielle Bernstein from the Legal Aid Society on behalf of Mr. Joshua Feliciano. For his first and only arrest and conviction, Mr. Feliciano received the maximum term of probation. Because nothing in the record indicates that he has a risk of reoffense commensurate with that length, we're asking the court for a modest reduction from the maximum, either to the minimum of 3 or to a term of 4 years. And it really is a modest request. He's at 2.5 years through probation. His expected end date is 2026. And so, this is a short amount of time we're talking about, but I do want to go through the factors that support that more tailored sentence.
Sometimes on probation, if you're doing well, the amount of time, the interim times that you have to go and report sometimes get extended. Has that happened for him yet?
Sorry, so the question is whether his
Like
check-ins
sometimes,
are
usually
now,
it's
there's more
every
time
month.
between check-ins.
And then after, if they're doing well on it, sometimes they'll extend it and say, okay, you don't have to come
As
until every 2
frequently.
months or every 3 months. Is he at that stage
I
yet?
haven't heard from Mr. Feliciano that the rate at which he has to go check in has changed, but I certainly can report that he's doing incredibly well. I mean, he's had gainful employment before this incident. He's currently working as a truck driver. He still has sole physical custody of his daughter and is her main supporter. And I think,
The waiver, valid or invalid?
Well, you know my answer to that, Your Honor.
I don't know. You could surprise me. You may surprise me.
So I think the way to think about this waiver, given that the standards here are holistic and we're looking at the totality of the circumstances, is there are specific issues that we point to in our briefing that
So what is this? Let's just get right to it. What's the specific issue that you think is wrong with this waiver?
Well, there are many, but the point I want to make, actually, Your Honor, is that I think looking at this, I promise I'm answering your question.
It's late. Okay, fine.
The order that the trial court went through here, and I appreciate the trial court went to great lengths to try to give a thorough colloquy here, and I credit the court for doing that. It goes trial rights, appeal waiver, immigration consequences.
Yeah, your
back to
argument,
appeal
okay,
waiver,
I'll make it simple.
discovery.
Your argument is that the defendant or the court was giving the impression that he was waiving his appellate counsel. Is that one of the arguments?
That is an argument, Your Honor, but our main argument actually is that the way that the court went back and forth in this meandering colloquy between different kinds of rights muddled the nature of the appeal waiver itself and what the right to appeal is for a defendant like Mr. Feliciano, who had never been in front of a court before, was appearing virtually because of the COVID-19 pandemic. And the very last question the court asks him is, do you still want to plead guilty at this time after discussing discovery rights and waive your right to appeal? The court elided these different rights. And again, I credit the lower court for its attempt to be very thorough here. A lengthy colloquy is not the same as one that prevents confusion. And in this particular instance, the way that the court went through this was meandering enough that someone like Mr. Feliciano, who unlike everybody here, had no idea what a right to appeal is or what an appeal waiver is, was left confused by the result of that waiver. And if I could just return to the merits in my last couple minutes here.
You got 1 minute left, go ahead.
I think the importance of what the value of probation is something that really should be focused on by the court here. All the studies we've submitted and that this court has reviewed in many other cases relating to probation indicate that the highest risk of reoffense really happens between the first 10 to 18 months of a person's time under supervision. And, we're past that point now, close to 2.5 years. And I think the question here isn't, does Mr. Feliciano deserve less time on probation? It's not a matter of lenience. The question is, what is the amount of probation that gets us to the point where the goals of probation, which are to prevent reoffense, are achieved? And for someone like Mr. Feliciano, who committed a very serious misstep, but for whom that was a complete aberration in a life of a law-abiding behavior, the risk that he would commit another offense like this one is much lower than the maximum.
How old is Mr. Feliciano?
He was 28 at the time of the incident, Your Honor, and he's in his 30s now. I think also the context in which he committed this misstep is one that speaks to the nature of the crime and the unlikelihood of it recurring. Because, this was the height of if I just could briefly finish, the height of the COVID-19 pandemic. If everybody takes themselves back there for a second, that was a time of deep uncertainty about people's behavior. And the answer to that is not what Mr. Feliciano did, of course, but it is the context that led him to be nervous about people's behavior, and a context that's not likely to arise again, hopefully, and one that he now understands would be a serious misstep. Thank you.
Thank you. Okay, counsel?
Good evening. If it please the court, Kate Trufant for the respondent. Briefly, unless there are questions from the panel, of course, the waiver was valid. As to what my opponent said about confusion, there was no confusion, and we know this because the court repeatedly asked the defendant if he understood the waiver, if it had been explained to him, if he was satisfied with his counsel's representation. Defendant repeatedly said yes.
They always say yes. I mean, what else are they going to say?
Well,
they always say yes.
Respectfully, Judge, though, what else can we go on if they're saying
I
yes?
understand, but to say, oh, well, we know he understood because he said yes. Trust me, they are in this cloud of, oh my God, I'm in this room, I don't know what's going on, I just want to get out of here and not go to jail. They will say yes to anything to get out.
Sure, but much like with our case at hand, we have a very limited 4 corners of the brief that we're looking at, and that's all we can look at.
Right.
He said yes repeatedly.
Right.
As to the sentence, this was a bargained for negotiated plea of probation. Quickly,
to go to the issue, right?
Mm-hmm.
What benefit is there to keep someone who is properly and dutifully responding to probation? We know that because if he hadn't, he'd be violated and put back in. It's that easy, right? So what use is there to keep him on probation for the full term? And is there not, in light of his limited background, right? And his very compelling personal circumstance. I mean, he was a very young man when he had this child. And I'm impressed that a 16-year-old decided, I'm gonna be a father.
I understand.
And at 28, he's still taking care of that 12-year-old. That should count for something.
It should, Judge, and it did, because he got probation and not jail time when he had a loaded gun on the streets of the city of New York. And the metric is not what is the harm in taking him off probation now. The metric is he has shown no special circumstances. People v. Fair, when absent special circumstances where a defendant effects a bargain, receives that bargain, he cannot later complain that he received what he bargained for. Defendant has not shown any hardship. To the contrary, he's gainfully employed, he's the primary caregiver of his daughter, he has strong family support. His life is continuing, and to his credit, right? But the metric is not, but he literally asked for this plea, and he got it, and that's where we are.
Thank you.
Thank you.
You have 1 minute. And I'm holding you to that 1 minute, okay?
Understood. So on the waiver, I do want to make clear, we're not asking the court to break new ground here at all. I mean, as Your Honor pointed out, in colloquies that were, defective in different ways from this one, the defendant always said yes. And I think, the prosecution keeps putting the onus on Mr. Feliciano to say that he was confused, as though that absolves the court of having to go through a colloquy the way that is required. And so I just want to make that point. But as to the merits, I think the distinction between probation and jail time, I appreciate that, no defense lawyer is going to come up here and say, oh, I wish he'd gotten jail time instead of probation. But the decision in giving him probation was that that was the appropriate form of punishment and rehabilitation, and within that, the question is how much probation. It's not probation versus jail time. It's when we're in the range of probation, what is the appropriate amount? And to Your Honor's point about Mr. Feliciano's, I agree, incredibly impressive life path other than this one aberration. I think that factor about his daughter who lives with him and who is supported by him is actually a really relevant issue here. One of the conditions of probation in his deal, I know I'm at the end.
That's it. We got it. All right,
thank you.
thank you. Have a good day, both of you. All right. SHCMG 25, Archdiocese.
Good evening.
Good evening. And I'm sorry that you have to greet us with that salutation.
I will admit, I don't think I've ever said that in here before, ever. James M. Catterson, Pillsbury, Winthrop, Shaw, Pittman, on behalf of the Athletic Club. My argument is probably the simplest argument I've ever put together before this court. There's one paragraph in the complaint. It's R77 of the record. It's paragraph 7. It's the only single factual averment concerning the Athletic Club in the entire complaint. It's correct, by the way. It's our address. It's 180 Central Park South. That's it. I'm not making this up. I know you've looked at the record. It is an exceedingly short amended complaint. And I say amended because, knowing the infirmities in the complaint, the plaintiff amended it and didn't fix anything vis-a-vis our client. And there's a reason for that. If you look at the complaint, again, it's 76 through 85 of the record. It's exceedingly short. The only paragraphs that even mention the Athletic Club are the following. I will go through them very quickly, I promise. Paragraph 19. I'll summarize it. The Athletic Club had a duty to properly supervise. They had a duty to reasonably manage, supervise, control. They had a duty not to aid pedophiles. Paragraph 20. They knew or reasonably should have known or knowingly condoned and or covered up the inappropriate and unlawful sexual activity.
So stop there, counsel. So
Yes, Judge.
what you're saying is that there need to be more facts to unpack how that knowledge came about, correct?
This court has been utterly and completely consistent since the 2010 decision I have a passing familiarity with. It's Sugarman against Equinox. In Sugarman, the complaint had a ton of facts. I'm sure you remember the case. It's the two knuckleheads, and I say that in the kindest possible way, peddling in a spin class at the Equinox. One guy is screaming, shouting, and having a great time. The guy next to him is not happy about it. They get into it. One knocks the other one over. That's the case. That's the case. And this court said the plaintiff failed to allege any facts that put defendant Equinox on notice that any criminal activity had occurred on the premises or would occur. It's a premises liability case, just like this. Now, there are a lot of facts in that case, and they weren't enough. That was followed up by, Justice Shulman, you sat on it, SG against Harlan Village Academy. It's the famous Drano bomb case. There were a lot of facts in that complaint, too, about some idiot kids combining chemicals in school that created an explosion that injured another kid. A lot of facts in that complaint. Wasn't enough. Followed up. Justice Manzanet Daniels, you know I would have found it. Shulman against the Aquatic Center.
You knew he was going there. Go ahead.
In that case, this court held that merely because somebody, and again, a lot of facts in the complaint, merely because somebody suffered a medical emergency that did not involve drowning, by the way, the owner of the facility could not be held liable for the lifeguard's failure to do something. It was, again, a premises liability case. You must allege something. Ulrich.
In the context in which this case comes up, with the CVA, with the Child Victims Act. At this stage, at this 3211 stage, courts have consistently held that, or at least this court has, that at this stage, you should go forward, that the facts that would illustrate the complaint are in the possession of your client. And so at least some discovery should happen first. What say you about that?
There is absolutely not a single case from this department under the Child Victims Act or any other premises liability that said there are no longer pleading requirements. Not one. The Child Victims Act did one thing, and I know everyone knows it. It extended the statute of limitations. Now, my adversary will tell you that they should get the benefit of the bounce. They do on a motion to dismiss. Any pled fact is assumed to be true. We all know that.
Right.
Those are basic rules of practice on tort law that have been around forever. I urge you to look at the 9-page complaint. There is literally not a single objectively verifiable statement about the athletic club, because that's the definition of a fact, other than our address. Not one. Thank you, Judge.
Thank you. Right on time.
Trying.
See that?
He's been here before.
Trying.
Good evening, Your Honors. May it please the court, I'm Rick Kroger from Simmons Hanley Conroy, arguing on behalf of SHC MG Doe 25. I think this is a fairly simple case, Your Honors. I believe that this court has decided a case very similarly. A year ago, I was here arguing GT versus the Archdiocese of New York, in which this court saw an equally short complaint that our firm drafted for a similarly situated plaintiff. This court upheld that complaint. The facts that I have alleged, that we have alleged in this complaint that matter in this are that the New York Athletic Club is a private club that allowed Father William E. Warren, a priest, to enter its premises with a 13-year-old boy. They then let that priest take that 13-year-old boy somewhere within the New York Athletic Club where he was able to have enough privacy to molest that 13-year-old boy.
Paragraph 20 of your complaint, pretty much.
Yes, it is.
Right, and assuming the truth of that allegation on a 3211, that's it.
We win. We won the first time. We should win again. This court in GT versus the Archdiocese said the same. I would point out NX versus Cabrini, which my friend has made much of. That case, this division, prior to the Court of Appeals hearing it, dismissed the case. There was a long dissent as to why NX v. Cabrini should not have been dismissed. The Court of Appeals took that case up and said, we agree that there's a bright line rule here and here with regard to sexual assaults being outside of the employment context necessarily, but what we don't agree with is that it's impossible for notice to come up, for notice to be formed based on the situation that took place. I would also note, importantly,
My colleague, Justice Mazinet, raised earlier about the Child Victims Act, the CVA, that the legislature has sent out a signal that, I mean, this is a special legislation that was giving life again to these type of claims, right? So
Yes.
that to cut them off at the pass, I'm not so sure if that's what the legislature intended.
The specific purpose of this statute was to allow litigants who had been harmed years and years ago in ways that are typically difficult to prove and difficult to bring up and difficult to discuss. The legislature saw that issue and said, these things have been hidden for far too long. We need to make sure that they can find justice. And that's what my client is doing. He's seeking justice. And as I would point out that almost all of the cases that have been cited that suggest this strict line that we somehow fall short of are summary judgment cases, which is why in most of these opinions, including the Drano bomb, including the fight, exception being Sugarman, to be clear, there's summary judgment motions. There's statements in the record. The court was able to say, plaintiff said this in their deposition, the defendants provided this information as to what they knew. We don't know anything about what New York Athletic Club knew about Father Warren. My 13-year-old client, almost 50 years ago, didn't know either. And when a person is brought into a hotel or a athletic club that's private at 13, to expect them to be able to remember which person was at the front desk, which person let him into this room, which person decided to leave when the priest molested him is a bit much. And I think, yes, this legislation was put there very much for this purpose, to let us and people who've been harmed like this proceed and find out what they knew and what they didn't. I'll be honest, if the evidence we have at summary judgment were the same, I probably would have a very different position. The court most certainly would. But we're not there. We're at the motion to dismiss. The lower court was right. This court was right in GT. The Court of Appeals was right in NX. These are all correct. I would say the distinction between this and Sugarman is that in Sugarman, there's no allegation that the premises were the cause or the use, the thing that was used as a mechanism of the abuse. Here, we have very clearly alleged that the New York Athletic Club was the mechanism of abuse, because but for that privacy allowed in this private club, that priest would not have been able to molest this 13-year-old boy.
Well, he wouldn't have been able to molest him there, right?
And so there may have been a different hotel, like Pantage is another case.
Right, I mean,
Again, Pantage is a perfect case to consider because, as Appellant points out, there's language in the opinion that it was in view of the front desk. There's no language in the opinion that says specifically that the front desk person saw the woman being carried into the room where she was being trafficked. Until we have discovery, we can't know all of the things that individuals at the New York Athletic Club knew that they should have used to stop this abuse.
thank you.
Thank you.
Justice Lang, I'm glad you brought up paragraph 20, because absolutely nothing what my friend just said is true. None of that is in the complaint. Literally none of it. The whole point about Father Warren taking the victim to some room in the athletic club and it was private and that's how this all happened, none of that is in the complaint. Not one word of that is in the complaint. Paragraph 20, defendants Archdiocese, St. Anthony, and New York Athletic Club knew and or reasonably should have known and or knowingly condoned and or covered up the appropriate unlawful sexual activities of Father Warren, who sexually abused the plaintiff. Not a single fact in that, not one. What I said in my opening was not controverted by my adversary. There is literally not a single fact in this complaint. This will be the first decision of this court that said a premises liability case can be based on a pleading of nothing but legal conclusions. On exactly that point, Pantages is a wonderful case. I'm glad my adversary brought it up. The woman who was abused was carried over the arm, unconscious, of the assailant through the hotel. Those are facts, objectively identifiable realities. There is nothing in this complaint. Brandy B, Eden Central School District. It's a Court of Appeals case from 2010. The only reason I bring it up is because it is a sex assault case. The premises, of course, is a bus, but it's still a premises liability case, and the Court of Appeals said the following: unanticipated third-party acts causing injury will generally not give rise to a defendant's liability and negligence absent actual or constructive notice of prior similar conduct. It must be established that defendant had sufficiently specific knowledge or notice of the dangerous conduct would cause injury, that is, that the third-party acts could reasonably have been anticipated. Court of Appeals, 2010. In that case, the mother of the child who was abused said, "Don't let that kid sit next to my kid on the bus." The assailant had issues that were in the record. The assailant had issues. The assailant was sat next to the victim. Nonetheless, the Court of Appeals said nobody knew that the kid was going to do this. There were no facts pled to suggest that this kid would commit a sexual assault. Here, you have nothing but the address of the athletic club. If this court is going to hold that the athletic club is liable, held in on this complaint based on 180 Central Park South, I would suggest, at least in terms of premises liability, It would be an earth-shattering decision. Thank you
It
very much.
wouldn't just be
Yes, Judge.
that that's the address. The complaint does say that that's where the plaintiff says the assault occurred, right?
Yes, Judge. That's not, of course, the test. The test is we had to be on notice that that the assault was, in the language of the Court of Appeals, specific notice of the dangerous conduct which caused the injury, or that the acts could have been reasonably anticipated based on the pleading. Based on the pleading. There is, I know I'm getting strident about it. There are no facts. Thank you very much, and thank you for hearing us out.
Thank you. All right. Premier 1122 Madison versus Halston.
Good evening, Your Honors.
Good evening.
Best for
Let him get
last.
up here.
Okay, the best for last.
You may proceed.
Thank you. On behalf of the appellant owner in this commercial lease dispute, the issue is really very simple. Did this tenant exercise an early termination option in accordance with the terms of the lease? So I am not going to be here to belabor how the many ways that this letter, which appears at page 108 of the record, does not comport with the terms of the lease. The lease clearly states as the most basic error that it has to be a 4-month notice. This was a 5-day notice. It was issued on January 26th, and the tenant said, I am leaving on the 1st of February. That is the most basic noncompliance. Then this letter proposes 3 different ways, which I've outlined in my brief at pages 17 through 18, of the options that the owner could take. That's not a notice under the lease. That's a proposal. A proposal. That would not have invoked an early termination option under the law. That is a very significant right that must be comported with strictly, because we are now here terminating a lease before, I believe at that point it would have been at minimum 7 years was left on that lease, prematurely. There are obligations that the tenant had under that lease for the entirety of the term. And then I turn to the guarantee, which also this letter at page 108 of the record purports to invoke the good guy guarantee and to release. Here again, you have the situation that under no circumstances was the rent paid up for that period.
And that was a condition precedent.
Correct, Your Honor. So in short, again, it's really outlined in detail in my brief. This early termination option was not exercised. The lower court should have granted summary judgment to my client. There was no issue of fact concerning this letter. The lower court said, oh, we have to figure out what the intent of the parties were. No, no. This is simply and clearly a comparison of page 108 of the record with the applicable lease provisions. It does not comport. Thank you very much.
Are we remanding to determine damages, though, even if we agree with you?
Yes. I will concede that there was a dispute regarding damages, but my appeal really focuses on liability. Should that early termination option have been found to have created an issue of fact? No. The court should have granted summary judgment on that point and remand for purposes of damages. Thank you.
Good evening, Your Honors. May it please the court. Lance Schinder with the firm of Black Shrevenick for the defendants, respondents, cross appellants, the former tenant and the individual guarantor. The argument has been made that there were no magic words in this lease. They drafted by the landlord. They certainly could have attached if they wanted something to be very specific, which is often done in banking cases. Exhibit B,
Well,
here's
how
the
to
draft.
exercise the early termination was very explicit in terms of how it had to be done. Was that followed to the letter as required?
So I believe every box was checked. Where we disagree with what I heard for the first time is this 4-month advance notice.
It's in the agreement.
No, but it's not a 4-month advance notice, respectfully. This is what it is. It's a 4-month window, which I think is critical to the analysis of whether or not it was effectuated.
But, I'm sorry.
No, that's okay.
Putting that aside, it is undisputed. In fact, you concede that you defaulted. In other words, at the time, let's accept that your notice of termination or the option was appropriately made under the lease. There was money owed then, and there was money owed post-termination.
No. So there are actually two different points in time, and we make this argument. When you look at the early termination option, it requires the defendant, the tenant, to actually be in default and not pay its rent. And I actually reached out to landlord's counsel because it seemed kind of odd to me that that would be the case. And I've cited into the record, I can cite it again, where they say, no, this lease is a true and accurate representation. There was no action for reformation, but I followed up on that point. This 10-year lease had a very limited 4-year window, not a 4-month window, not a 4-month notice. It does not say that.
Okay.
It says you have a period of 4 months. The affidavit by the drafter said I knew that 4-month window, and that's one of the reasons I exercised it then. What could be clearer than not only are we exercising it and effectuating it, here's the keys we're leaving. They're not off the hook.
You also had a Plan B and a Plan C as well in the letter.
Well, remember, that letter was doing a couple things. It was also exercising the good guy clause, and in the good guy clause, there is a part at the end of the surrender conditions where the landlord is supposed to agree. So that's there. That at the end, it also says the lease as modified herein. In other words, modified here in that letter, except as modified here in that letter remains the same. Except as modified in that letter.
Are you saying, wait, we need to go back to the tenant had not paid all its rent
Right.
at the time that this exercise of early termination.
Yes.
That is a correct statement. There was rents due that had not been paid by the tenant.
Yes. And
Correct?
yes.
And then, so in Article 6.01, it says, tenant shall not have the right to exercise its early termination option if, and B, the tenant shall not be in default under the lease.
Shall not have the right if not in default. It's a double negative. They
Right,
have
the
to
double
be in
negative,
default.
that's the whole drafting issue that was coming up.
They have to be in default when you read that language. That's what it says. I know it's bizarre.
We're not gonna resolve that today.
And I reached out, that's why I reached out to opposing counsel, and they wrote back saying it's true and accurate. It says that double negative makes them have to be in default, and they were. They owed money, and then days later they paid $131 some odd thousand, but there's no 4-month advance notice.
Okay.
They turned in the keys without objection. They surrendered without any kind of objection. The very first time we're hearing anything about this is in this case. I mean, what is the common sense, logical conclusion? What I did raise in the argument below is, what if the internal memos, what if the landlord understood, because it's exercised during this very small window, that that's what they were doing? What if the landlord said, we know they're exercising their early termination option?
Continue.
What if the landlord said that? This issue's moot. They understood it. Why would we be continuing to talk about this? The landlord would say, yes, and to the point of the double negative, A tenant with a 10-year lease that has a 4-month window to knock it down to 3 years, there would be 11 months left on this one. What kind of tenant would take a 10-year lease down to 3? A tenant that was not surviving. We cited to the email that same day from the CEO and the guarantor to the landlord and said, sorry, we cannot make a go of it. We have to leave. Also, with regard to the good guy clause, what I don't think jives, sorry to use
It's
a
all right. Go ahead.
slang word. On the one hand, because in our opposition below, we showed their damages are a moving target. We have 4 people in an amended complaint. So this is the second time.
Well, there's clearly an issue about how much the damages are.
But in 10 places, say on March 10th of 2015, 47,000 and some exact numbers were owed. If that was correct, then there's impossible that anything was owed in February, because the rent's more than that. The rent was $60-something thousand a month. What they've done in this case, they dropped a footnote, and they pawned it off, and they said that was a mistake. Wait a minute. This was your second complaint. It was verified by 4 people in 10 different locations. Why do we accept your numbers? And number 2, as you've pointed out, in order to exercise the good guy clause, that you actually could not be in default. Well, if you are saying to this court, which I think they're saying, let's have a hearing on damages, the two are inextricably intertwined. How can you determine we don't have a good guy clause issue when we'd have to prove we were not in default, yet on the other hand, you're saying, take us down to just determine damages, liabilities is slam dunk. You can't determine the non-liability of the guarantor without looking at the damages. The two are
Even assuming that the early termination was properly effectuated, your client would still have to pay the rent for that entire year.
Yes, Your Honor.
Okay, all right.
Yes.
Thank you. And you have
what-
time on rebuttal.
So I had a cross motion. No.
Them, and then I'll give you another minute, okay?
I would just like to address the question of the double negative, because that does seem to be a confusing part of the lease clause. And what is undisputed and is that the guarantee says, tenant shall have made payment of all fixed rent and additional rent due as of the surrender date in order to invoke the guarantee, the release of the obligations. There's no question and no dispute that the tenant had not paid the full amount of the arrears. We don't know the extent of it by the surrender date that they propose in their letter, and certainly not on the 5th month after giving the notice. So just on that, it was undisputed that that condition was not met. That's as to the guarantee. Now, going back briefly as to the early termination notice, I also would like the court to look at the fact that the lease says that the early termination date is a defined term, and it has a date, December 31st, 2015. It could also be off by 1 or 2 days, but clearly that is not the surrender date in the notice that they gave. So that is also another non-compliance with terms of the lease. So on both grounds, both the timing and the actual content of the letter.
Couldn't they exit the place in February and then keep paying rent until December? That's what they argue. I mean, so that's a possibility too. I mean, but that goes to whatever your damages.
Exactly, Your Honor. It doesn't go to whether that letter invoked the option, and that's our position, Your Honor. It did not, and therefore, this lease was not terminated early.
Thank you. You have 1 minute.
Thank you, Your Honor. If you look at 6.03, it's that same article. It specifically says the tenant can leave early, can surrender early. It doesn't mean they're off the hook. They're still on the hook for the next 11 months. That's not being disputed. And last but not least, they've made an argument with regard to liability, and let's just go to damages. The judge specifically did not grant summary judgment on the counterclaims, on the tenants and on the guarantors. The guarantor has, in paragraph 12, a right to enforce the good guy clause, or else it's meaningless and illusory. That counterclaim was the summary judgment was denied as to the counterclaim. The very first time the landlord argued that, in this case, is in their reply brief, which was not correct. And so, again, if you would end up reversing this, it would almost have the trickle-down effect of taking away the ruling on the counterclaim. Because how could you determine liability when we still have our counterclaims pending, and they should not even be subject to this appeal? They were never mentioned at all. And so, again, respectfully, we think that the decision should be affirmed. The only part of the decision was the part that said we did not oppose the motion to dismiss our defenses. The entire backbone of our opposition was our defenses. Thank you very much.
Thank you.